Welcome to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. And don't forget, comment, like, and subscribe. And if you love this channel, please become a member. Good morning, or should I say almost afternoon, everybody. We have been over in the South Carolina Supreme Court watching the Alec Murdaugh hearing, or an appellate hearing, and I think we're going to have another Murdaugh trial. But in the meantime, I have got a set up. We're going to go straight into Faust, and we're going to be, we're going to see what shenanigans happen today. So let's go ahead and get on in there and zoom through because we are late. We are late to court, Your Honor. So let me get this zoom back to where we have court, glorious court.
All right,
There we go.
Back on the record. I'll start with the state. Anything you would like to add? And Mr. Cruz, Mr. Hill, you'll get to respond. Go ahead, sir.
Thank you, Your Honor. So one thing that I know that the court has already found that information related to the CODIS hit is relevant. I would also add, just to kind of support that even further, is the fact that there are particular counts of this indictment that reference that April 30th, 2024 date. And so that is necessary because of tolling of the statute of limitations for certain counts in the indictment. So that is a material fact that the state has to prove as well. So that again, I think just supports the idea that this is absolutely relevant evidence related to the CODIS hit and when that hit was generated. The case that I would cite to the court is Watson v. State. That is 337 Georgia Appeal 16. It is a 2016 case. And just so the court understands kind of the procedure or the procedural posture in Watson, I guess the argument was that trial counsel was ineffective for not objecting to information about CODIS being brought into the trial. And which is obviously different than the situation we're in here, but I think that the language is still helpful. And Watson stands for the proposition that evidence of that a defendant's DNA profile is included in a database compiled would reflect badly on the defendant's character if the DNA profile or references to the database linked the defendant to criminal activity. And so the state has been very clear. We have instructed our witnesses very clearly to not refer to it as anything to do with criminal activity, just that it is a known database, or let's see, a national database of known DNA profiles. Watson also says that there are other ways that a profile might get into CODIS, of missing persons, evidence collected at crime scene. So it's not just offenders whose profiles go into CODIS, but we're not even going to get into that. Just the fact, and again, our witnesses have been explicitly instructed to refer to it only as a national database of known DNA profiles with nothing further. So I think that under Watson, because we're not in any way, shape, or form attempting to link it to Mr. Faust's criminal activity, then there's no issue.
All right, thank you. Mr. Cruz.
Yes, ma'am. I would say Based on the state's case, I haven't read the case, but I think it supports our position. It is linking Mr. Faust to criminal activity. They're saying the basis of this entire prosecution is based on Mr. Faust's DNA, supposed DNA being present in Ms. Baker's body, Your Honor. The entire piece of the testimony from Mr. Howell that's anticipated is to state that we previously had your DNA, or do you know how we previously had your DNA? Prison itself is linking them to criminal activity. Well, excuse me, let me clarify that. The only reason the state will previously have Mr. Faust's DNA is through incarceration or felony conviction, as the Honorable Court is aware. But they are also using that DNA with the CODIS to state that, hey, this is how we connected Mr. Faust to this crime. So that's my position, Your Honor. I do not have any additional case law. I figured the Honorable Court would, I leave it to the discretion of the Honorable Court, but I would say without reading the case that I believe from what was proffered, it supports our position. Secondly, the standard, as the Honorable Court knows, of effective assistance of counsel is very, very high. So in regards to the court's ultimate finding on that case, it has to be looked at the standard. As the Honorable Court is aware, on the trial level, the presumptions are in favor of the defendant.
Thank you, Mr. Cruz. All right. I first want to respond to both parties this way, as I sort of did before I left the bench. And that is, in the arena of this case, both parties questioned the jury about submitting DNA to other sites, right?
I did not.
Okay. You may have followed up with questions.
No, I
about it.
didn't follow. I didn't talk about submitting DNA to sites at all with the jury.
All right. Thank you, Mr. Cruz. I'm stand corrected. Then it was just the state. There were no objections, but it was just the state. But my point about all of that is that there was discussion in voir dire, okay, by the state, that referred to whether persons had submitted DNA for well-known sites. I mentioned the ones that came to the top of my mind. I don't remember if you all did this in jury questioning or not. I'd have to look at my notes. But of course, Ancestry.com, it's 23andMe, not 21andMe. I don't know where I came up with that number. And things of that nature. And so I say that again to, I think that is a background of how it is certainly possible for the jury to recognize a CODIS database as being just a database like any other. There's been no evidence, in addition to that, in this trial, that the CODIS database is necessarily only linked to persons who have been incarcerated in the prison system. All right. That being said, the reason I left the bench is because I wanted to look at what the law says. And that is what is going to dictate this court's direction. It's what the law says. The law is clear, but I want to explain what the law is. But the law is clear that it is allowed. The law is very clear in this state that what this state is seeking to introduce is permitted. That's in Scales versus the State, 310 Georgia App 48, a 2011 case. It is still good law. The interesting language in this case, and I'm reading it to all of you, and I'm going to actually read some comments from a law review article that sort of mimics this case to tell you how I'm going to tailor or order that this evidence is tailored. I'm going to allow it, but we're going to do some tailoring. This is what the case says, which is Scales. Evidence that a defendant's DNA profile is included in a database compiled by a state or federal government agency would reflect badly on the defendant's character if the DNA profile or references to the database linked the defendant to criminal activity. Therefore, we hold that evidence of a matching DNA profile in a government database does not, in and of itself, constitute impermissible character evidence when no reference is made as to why the matching sample was collected or stored, and when no reference is made linking the defendant's DNA profile to other criminal activity. Other states have reached similar conclusions, and that's the law. So in looking at the law in the state of Georgia, I wanted to just see what else was out there in the brief moments that we had. There is a law review article that is, I'm looking for the date, that is from December of 2025, so a very recent article. And I'll just read it to you all, just so I don't have to summarize it in my own words. In cold hit cases, prosecutors may wish to introduce evidence to the jury regarding how the defendant came to the attention of investigators. Specifically, the prosecutor may feel that the jury will wonder why a particular suspect was selected in the absence of testimony regarding the database search. This sentiment may be especially acute in long, dormant, cold hit cases in which a great deal of time elapses between the offense and the prosecution. Generally speaking, defendants have sought to preclude such testimony. Occasionally, trial courts grant such motions, typically made on Rule 403 prejudice or Rule 404B character grounds, as you have made, Mr. Cruz, and allow the prosecutor only to elicit testimony such as that the defendant came to the investigator's attention as a suspect. However, the majority of appellate courts that have reviewed denials of motions on this basis have been upheld. Scales versus the state, which I just mentioned to both of you, to all of you, is typical of the handful of courts that have addressed the issue, and that the court declared, quote, that evidence of a matching DNA profile in a government database does not in and of itself constitute impermissible character evidence when no reference is made as to why the matching sample was collected or stored, and when no reference is made linking the defendant's DNA profile to other criminal activity. And so I wanted to just read that to you. I mean, I realize a lot of your articles are not law, but it does support the case that the court feels is appropriate to rely on. So I'm going to allow the question, but we're going to limit the question in this manner. We're going to narrowly tailor the state's ability to present this evidence. First of all, the only permissible reference to CODIS is going to be with the words that it is a national database, not a government national database, a national database. I want to pause here for a moment and also say this, that we looked at a few other cases in the country that were cold cases, as we all have been discussing, out of the presence of the jury, as to whether this issue came up. And the evidence in several of those cold cases was that the defendant's DNA profile, the mediums that I have described, were mentioned during jury selection. They were collected using Ancestry.com and 23andMe and other DNA other agencies that collect DNA. And those cases were referred to as national databases, but they were not criminal in nature. They were not CODIS, but they were national databases. So I think the reason I want to mention that is I think it supports my feeling earlier that I articulated to all of you that, my sense of the evidence that I articulated to you all earlier, that there has been no mention that the general public understands that CODIS in and of itself is a government national database that deals only with people who are incarcerated. There are a lot of national databases, so to speak, that are in the public realm that I think it's fair to say the public can look at as all being the same. There's been no evidence in this trial to suggest that CODIS is only for defendants. So I just want to mention that. All right. So let's go back to tailoring the state's question. If the state seeks to elicit this information, it has to be as a national database, not a national government database. There will be no questioning unless the defense decides to do it as to what CODIS is, other than just articulating that it is a national database. I am making a finding under 403 that it doesn't violate 403. I mean, I certainly don't disagree that a lot of relevant evidence is prejudicial. I mean, that is the law. That is, there's an argument to be made that all evidence is prejudicial. The question is whether 403 is violated, and 403, of course, is relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, etc. And based on the law that the court is using, which is Scales versus the state, I'm making a finding that 403 is not violated. And so I'm going to allow you to ask that question with that instruction.
Your Honor, if I could just preview for the court the question that I would ask to make sure that I'm in
Right.
compliance with the court's order.
Right.
Anytime that we make reference to, and I can only think of 2 times really during the direct examination when this will come up. The first time would be when we're talking to Agent Howell about how it is that Mr. Faust entered as a suspect in the case. And then the second time would be, as I referenced earlier, during the playing of the interview, asking him immediately before Mr. Faust made the statement, did you reference his DNA being in a national database of known DNA samples? And that's the same way that I would ask that question to Agent Howell as far as how Mr. Faust entered the investigation. I'll ask it in a leading manner to try to control it as much as possible. Your Honor, I would ask Agent Howell, did Mr. Faust come to y'all's attention as a suspect in the case based on the presence of his DNA in a national database of known DNA samples?
All right. Well, before I say anything, Mr. Cruz, do you care to respond to Mr. Yellowman-Chili's proffer of how he's going to ask the questions?
Stop the question at known DNA database because Mr. Howell is in the courtroom, so he knows exactly what the question is seeking to elicit.
Well, and that's important so he knows how to answer it and not violate the court's rule, but sure.
Since he knows how to answer, can we just stop it at national database?
I thought that was the end of your question.
Well, he said that
A national-
known DNA profile. So we can just stop it at national database. Mr. Howell knows the testimony that suspect. Just trying
Okay. Okay.
I understand the coach just trying to limit any potential prejudice.
I understand. Would you like to respond to Mr. Cruz's request?
Well, I'm just trying to establish that it's a national database of DNA. And
I
so
think that's the
how,
best way to say it.
okay.
I'm going to just say this, Mr. Cruz. I'm going to grant your motion. I think the best way to say it is a national database of DNA.
My request was just stopping it at national.
I understand. So I'm sort of granting your request, I suppose, in part, and I'm granting the state's request in part. I'm not going to, I think it is appropriate to limit even the end of the sentence as Mr. Cruz has asked. You are going to say no national database of known DNA profiles. The best way to say it is a national database of DNA.
Yes, Judge.
Period. All right. So I'm going to grant your motion in part and overrule it in part. I'm going to grant your motion in part and overrule it in part to elicit that information. You do have your agent here. I know that, and he's allowed to be in the courtroom based on the statutes. But I'm going to give you a second to talk to Agent Howell and make sure that you all are on the same page. And is there anything else we need to talk about though before we bring the jury in?
I need to proffer 2 things on the record, if that's okay.
Of course.
And I'm just proffering for the record, Your Honor. In regards to the testimony of Elizabeth Bigham yesterday, in regards to the court's ruling about Mr. Faust's living situation and the address he stayed at in the weekend of Ms. Baker's death, the expected testimony would have been that Ms. Bigham, based on her review of the case file, would have known that Mr. Faust stayed at Knollwood Apartments.
Hold on a second, Mr. Cruz. What are you proffering a question you're going to ask?
No. So yesterday I didn't do it, but I was supposed to, anytime testimony is excluded or evidence is excluded, I believe pursuant to Rule 103, and I can check my notes, I'm supposed to proffer the excluded evidence into the record for appellate review. So that's all I'm doing.
Okay, well, I think that is untimely at this time. If you care to call Agent Bigham back on cross-examination and you want to bring up those comments, then you certainly can do so. But I think now it is untimely.
Okay. Question for you. With Mr. Howell, I do intend to ask him a general question. I want to make sure it doesn't violate the court's order.
All right.
Can I ask him generally, was he aware of any information suggesting that Mr. Faust did not stay at 350 Cooper Road on the weekend of Ms. Baker's death? Okay. Is that a permissible question for them to report?
Before I answer that, I'm going to let the state respond, if you care to respond.
As long as it's information that draws on his personal knowledge, I think that he could ask that question, Judge.
I mean, I sort of agree with the state. I mean, I think in and of itself, again, that question is not necessarily impermissible. If there is if the manner in which you ask it or the manner in which the witness responds is indicative of an objection that the state needs to make, I'll hear it. But it just in and of itself, the question you've asked is not prohibitive of any ruling the court has made.
Sure.
That's what you're asking.
Yes, ma'am. And just to make sure, it's undisputed that Mr. Howe was an agent of the state. In the event that he says no, I would move to impeach him by contradiction. And the impeachment material would be the document that I showed the state yesterday. And that's why I want to ask to make sure that's
Okay. Well, if we have to get to that, we'll get to that. And I'll certainly take up any arguments that may need to be taken up at the time. If I have to send the jury out, I will. I don't want to make, this is a pretty nuanced argument that you all are making. And I think it's making it in a vacuum is not something the court can consider at this time. If you ask a question that the state objects to, I'll hear it and we'll talk about it. And if you all want me to send the jury out to do that, I will certainly do that. But the answer to your initial question about that particular question in and of itself is not violative of any ruling the court has made.
Yes, ma'am.
Okay.
Thank you.
Thank you. Yes.
Your Honor, I was patiently waiting my turn about the DNA stuff because
Okay.
I also have a witness this morning that will testify.
Oh,
about
good.
and she's
Okay.
not in here right now,
Right,
and I
of
want to
course.
make sure that she is instructed,
Okay.
consistent with the court's ruling as to how to answer. I will again inform her that CODIS is to be referred to as a national database of DNA pursuant to what the court just articulated. In fact, I would also intend on, just to avoid any potential for confusion, ask that in the form of a leading question to her.
Okay.
Now, with this particular witness, the state had intended to go a little bit further, and I would like to flesh that out before, outside the presence of the jury. This particular witness, Ms. Sims with the State Crime Lab, is familiar with how many known profiles are in the database, and I had intended on eliciting that from her. I would still intend to, unless the court tells me not to. And then, so that's the first thing. And then
I'll let you respond, Mr. Cruz. Don't worry. Let me let him go through his argument, and then I'll let you respond.
And then, so Ms. Sims is the forensic biologist who obtained the profile from the sexual assault kit that was eligible to be uploaded into CODIS. And so my intended question to her would be that once an item is entered into CODIS, what happens? The answer that I expect her to give would be something to the effect of, it is compared on a routine basis to other profiles found in the database. And that would be the extent of it.
Okay.
So again, I thought it made sense to bring that up now, since we were talking about CODIS and DNA and all that. And I certainly want to have this witness prepared to answer in a way that would not be inconsistent with the court's rulings. I can do that. I just, again, she's not in here right now. So I thought this was a good chance to raise that issue.
Thank you, Mr. Cruz.
I would just ask that it's similarly limited in scope. What I would ask in regards to Ms. Sims' testimony, if the state and the Honorable Court agrees, wants to get that she made the extraction to make it an identifiable DNA profile, I have no issue with that. But once we get into that, a GBI agent is uploading it into a national database, we go from, as the Honorable Court stated, just a national database that could be 23andMe and other sources, to inferences that this is a government database that the GBI is using. So I would ask that it's limited.
All right, thank you. I think the law allows what the state is asking, and so I'm going to allow you to do that. I think the tailoring you're asking for, Mr. Cruz, is not supported by the law. Whatever inference, if an inference is made by the jury about why an agent may have had access to the database, is an inference that is not supported by the evidence, and it's not going to be allowed by the evidence. You haven't said there's going to be testimony as to why the GBI agents, of course, had access to the database. I think that would not be something that's permissible based on this discussion and my ruling. So I understand what you're saying, but it's not supported by the law in this case. So I'm going to allow you to ask that question. I do think that is permissible under scales. It is important, certainly, to instruct your witness. Let me ask this question. Do you want to do that now, or do you want to wait until that witness is called?
I think we could wait, Your Honor.
Okay,
But,
okay.
Again, since we were all talking about CODIS and DNA,
Sure.
I wanted to have,
Okay.
in my mind, what would be permissible under the court's
Okay.
ruling. So not only the fact that it would be routinely compared to other known profiles in the database, but the other question that I had referenced was how many known profiles are in the database.
I understand what you said. I mean, I don't find anything impermissible about that.
Making
Mr.
sure
Cruz, you didn't respond to that, but if you'd like to, you certainly can.
Well, it goes to both, but
Okay,
I do understand
okay,
the honorable court's
sure.
ruling.
Okay, all right, thank you, sir. I'm going to allow it. I don't find it valid of 403, but certainly I'll let you in one moment, Mr. Yalman-Chile. I know Agent Howell is sitting in the courtroom. He's heard everything the court has said. I'm going to give you a few minutes to make sure that you all are on the same page about that limitation. Mr. Cruz, I certainly will hear from you, but I want to make sure I don't forget this. The state has asked twice to be able to ask one or two leading questions with regard to this issue of their witnesses. Do you have any objection to that?
At this time, I do not.
Okay.
I just wanted to clarify the record. The honorable court mentioned 403 as the ground. Our objection was also under 404B, and I understand that it was
Understand.
on both grounds.
Yes, sir. I understand. And I find that it's not violative, but I certainly want to make a finding on the record about 403.
Yes, ma'am.
Thank you. All right. Is there something else you wanted to raise? All right. If you need a moment with Agent Howell, you can do that, and then we'll bring the jury in. Thank you.
Okay, so now they're going to bring the jury in. They had that discussion over whether or not the jury will be told
By the
how they
jurors.
will be told about the DNA evidence and the language that they use. This will be interesting.
Obviously by name, or take a picture of them, or a video, or anything. I mean, I know you know that, but I just want to mention that. I don't know whether that actually happened for a brief or any other.
Okay, now we're going to address what happened yesterday. Yesterday, they accidentally got the jurors leaving the courtroom because the jurors have to go down the center of the courtroom. There apparently is one door in and out for them. And unfortunately, yeah, that caused some
Is the
trouble.
defense ready?
Yes, ma'am.
All right, thank you. I do want to mention one thing for our media persons who are here this morning, sir, and other
Yep.
persons who are here. There was something online that was brought to my attention by
Mhm.
the state, and I don't know whether this happened or not, but somebody posted something that suggested that the jurors might have been shown leaving the building.
They were.
And I don't know whether that
Oh,
is
I gotta
accurate or
edit
not,
that
but I
out.
just want to make sure every media person in here understands that in no way, shape, or form can anyone identify the jurors, obviously by name, or take a picture of them, or a video, or anything. I mean, I know you know that, but I just want to mention that. I don't know whether that actually happened for a brief second or not.
It did.
I just want to bring everybody's attention. Thank you very much. All right, you can bring the jury out. Thank you.
It sure did. Yeah, I had to leave last night. I had to take care of some business, so I need to go back and edit that out. I'll do that right now. And it takes a while for the video to download for me to be able to edit it. So I'll go do that right now. Let me go edit all that out so we don't have a problem. I want to respect the privacy of the jurors.
You all may be seated. Thank you. Good morning, ladies and gentlemen. Thank you for being back here on time. We are getting started a little bit past schedule. I'm sorry for that. But as always, there are things that we need to take up outside your presence. This one took a little bit longer than I had anticipated. I do appreciate your patience. We are ready to begin. We are here to resume the trial of the State of Georgia versus Edric Faust, SU 24 CR 0547. Is the state ready?
State's ready, Judge.
Is the defense ready?
Yes, ma'am.
All right, thank you. You may call your next witness, Mr. Yalman-Chile.
State calls Agent Jeremy Howell.
Agent Howell?
He's on the stand for a long time, y'all.
Sir, I'm going to ask you to take an oath. You raise your right hand. Do you swear or affirm testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear and affirm.
If you would, please take a seat, speak towards the microphone, and state and spell your name for the record.
My name is Jeremy Howell. That is JEREMYHOWELL.
Sir, where are you currently employed?
I'm currently employed by the Georgia Bureau of Investigation.
And how long have you been with the GBI?
I've been with the GBI nearly 15 years.
All right. And what is your current assignment with the GBI?
I'm currently assigned to the Office of Special Investigations Cold Case Unit.
And before you were with the cold case unit, what was your previous assignment at the GBI?
I started out in 2011 as a special agent. I was assigned to the Region 15 office, which is down in Sylvester, Georgia, which is down in Southwest Georgia. I was there for about 2 years. Then I had an opportunity to come up to the Region 11 office, which is in Athens, Georgia, where I was a crime scene specialist for a decade.
And you mentioned being a crime scene specialist for a decade. Do you have any particular role or specialization within the cold case unit?
Yes. As a crime scene specialist and a former trained crime scene specialist, I bring those skills into assessing crime scene summaries and other things related to cold case investigations.
And how many years of law enforcement experience did you have before joining the GBI in 2011?
I've been in law enforcement since 1998, in a local level from 1998 until I joined the Georgia Bureau of Investigation in 2011.
When did you move to the cold case unit?
I joined the cold case unit at its inception, which was July 1 of 2023. That was a weekend, so our first day on duty was, I believe, July 3rd of 2023.
At any point while you were in the cold case unit, were you assigned the murder of Tara Baker for investigation?
Yes, I was assigned to assist Liz Bigham as she was assigned as the the lead of the investigation, and my responsibility was to assist her in that endeavor.
Once you were assigned the case, what process did you go through as far as your reviewing of the case file, and how did you familiarize yourself so that you could begin your investigative acts?
Our first step in the process was to partner with Athens Clarke County Police Department. We wanted to centralize all of the evidence and also all of the case file that they had. They were kind enough to grace us with a securable conference room at their West Side precinct, which is over by the mall. And we had secure access to that. So we consolidated all of their case files there, as well as all the evidence there. And the first thing we wanted to do was assess those materials. We wanted to modernize the case file, which was to scan everything and make it into a searchable format as a PDF. We also wanted to inventory all of the items of evidence and compile a list of what we had, what had been done with it, and seek other potential things that we could do with that evidence.
And was this a process that was completed in a day, or did it take longer than that?
It took much longer than this. There were multi-volumes to that Athens Clarke County file. There were multiple items of evidence. One of the things that we are graced with the cold case unit is the gift of time and resources. So we methodically and meticulously go through these items in order to catalog them and also to modernize and review them.
As it relates to the volume of the information you had to digest or the size of this case file, how did that compare with other investigations in which you had been involved previously in your time in law enforcement?
This was the largest case file I have ever been a part of reviewing. There were over 21 large D-ring binders that were associated with this Athens Clarke County case file alone. There were over 5,600, I believe, 87 pages of material that were in those binders. There was also a separate PDF electronic copy of the case file that Athens Clarke County provided us that was 4,224 pages as well. And there were also a number of photographs that were within that case file.
And in particular, the photographs, this crime that you're investigating took place on January 19th of 2001. Is that correct?
Yes.
Okay. Back then, when crime scenes were processed, are you aware of whether or not the Athens Clarke County Police Department was still using, I guess, film-fed cameras? I don't know how that terminology works exactly.
Yes, they had film photography back then, and I believe digital cameras were pretty much in their.
Trying so hard not to interrupt, but I love it. They had film cameras back then, and I think digital was just beginning. Oh my God. I laugh because I was a professional photographer for buku years, and I used film only. And I'm talking medium format film, not the 35 millimeter, medium and large format slide. I did it all, and I had a very good, thriving business. In fact, I was pretty wealthy back then. I was extremely wealthy, actually, if you look back at what I was earning back then. And I had a lot of work, ton of work. Love the business, but that cracked me up. I'm sorry, y'all. That was funny.
Infancy
That's
back
funny.
then, and there were a few digital images.
Okay, so the images in this case, were there images that were not stored digitally?
Yes, there were crime scene photos.
I mean, there were photos you can hold, put your fingerprints on. Yes.
That were mainly in film, and they had been printed out onto a print format and scanned. But one of the things that we wanted to do with the film negatives, it was to digitally scan those so that we could enhance those to the best that we could and collect as much data as we could, transitioning or transferring those film negative images into digital images with a digital scanning device.
And was that all part of what you referred to earlier as the modernization of the case file?
Yes, that was my responsibility.
Okay. And so let me ask you a little bit about your background and training specifically as it relates to crime scene processing. Can you tell me a little bit about your background and training in that area?
Yes. When I worked at the local level, I received some training at an academy up in North Carolina. It's called Searchy. I attended Searchy, I believe, in 2007. It's a 40-week program where you learn crime scene processing, and they're also a crime scene processing equipment provider. So you learn how to utilize the equipment that they produce and that they also market. When I joined the crime scene unit, one of the things they do is they send us to a 10-week program at the National Forensic Academy. That's also known as the Body Farm, but it's much more than just the Body Farm. It's a 10-week program in which
It's a body farm. You know, I'm loving him. Love him.
each week is dedicated to a specific discipline. It starts out with crime scene documentation. It then moves into crime scene photography. Then it moves into latent print processing. And from there, you also learn bloodstain pattern analysis, shooting incident reconstruction, utilizing an alternate light source in order to be able to detect trace evidence, which is fine evidence that sometimes needs a little bit more help with technology in order to be able to visualize. There's also a component of arson and explosive investigations associated with that. And there's the body farm component of that, in which there is a facility off campus that has multiple deceased individuals in various states of decomposition. And you learn all of the aspects of death and decomposition based upon actual hands-on experience at that facility.
In your role as it related to this case, were you able to review the documentation of the processing of the crime scene at the time of the crime?
I was.
Okay. Can you tell me a little bit about any type of environmental challenges, if any, that existed with the processing of the crime scene in this particular case, as well as the collection of trace evidence in this particular case?
Yes, this was a very dynamic scene. Short of a natural disaster or an explosive event, this presented many challenges with the aspects of the environment. One, you have a fire event that is occurring there. And that is what the initial response and the initial call is. So the initial first responders are responding to a fire incident in which forcible entry needs to be made into a residence in order to conduct search and rescue operations and also to do fire suppression activities. I have experience with fire. I was a volunteer firefighter when I worked in the Madison County Sheriff's Office. I was also a volunteer firefighter with the whole volunteer fire department in Madison County. I spent 5 years in that role.
Your Honor, something just came to my attention. Can we approach the bench?
Okay.
Whoa. Sidebar. Y'all. Oh, excuse my nose. How many of y'all are still struggling from allergies? It's better today, I'm told, but I'm not feeling better today. So, what chance will we see the prosecution rest? 100% said no, 75% said yeah, 50%, 25% of y'all said 50. So, 75% of you think 75% chance I'll rest today. 25% of you think 50% chance I'll rest today. Nothing for 125. I'm going to go ahead and, no, I ended the poll. Thank you guys for joining us so much. We are just now starting the Faust trial. We watched the Alec Murdaugh appeals case before the
Yes.
South Carolina Supreme Court, and now we're hopping into the Faust trial. Thank you so much for joining us. Oh, wow. Well, I guess I thought we were going to get back into it. Maybe, maybe not. Let me zoom.
I think where we were,
Okay, here we go.
Agent Howe, I think where we were, I actually kind of kept up with it, I believe, as you were discussing your previous fire experience.
Yes, and when I was with the volunteer fire department in Hull, one of the things I had the opportunity to do was to attend training at the National Fire Academy, which is at Emmitsburg, Maryland. I attended 2 different classes there. One was fire cause determination for company officers, which is a basic level arson determination class in which you learn how to do points of origin as to where a fire source may be. And I also attended a week-long training in incident management for large-scale incidents. When I was with the GBI, we also received, in addition to the training at the National Fire Academy or the National Forensic Academy with arson and explosive investigations, we also would do training at our facility here in the state of Georgia, the Georgia Public Safety Training Center.
I'm so sorry, boo. Oh, babe, I am
because it's a
so
completely different aspect
sorry.
of photography, trying to photograph.
I am
and
so
document that type of
sorry.
environment.
As it relates back to, you were describing some of the challenges at the crime scene. That's the context in which we entered a discussion about your previous experience with fire. How does moisture, especially heavy levels of moisture, affect the ability to collect trace evidence at a crime scene?
So as a fire smolders and consumes in order to be able to fuel its existence, fire suppression activities, you need to introduce water into that environment in order to be able to suppress that fire. That's normally under a pressurized line. There will be a spraying of water within that environment, which will add moisture to that environment. That in itself will move and rearrange the environment and also provide an element of destruction to that environment.
Objection, improper expert testimony or improper lay witness testimony, either one.
All right. Any response to the objection?
Your Honor, Agent Howe is testifying within the purview of his knowledge and training and has not offered an expert opinion on anything.
Yes, sir.
I'm assuming Agent Howell is attempting to take his testimony and apply it to the scene. So if he's not testifying as a expert, if the state is saying this is not improper expert testimony, our objection would be relevance. This testimony would be irrelevant if he is not trying to apply it to the scene of Ms. Baker's home.
All right, thank you. Any response to the next objection about relevance?
I believe, Agent Howell's involvement in this case had to do specifically with, at least in part, his training and experience processing crime scenes and his determinations about what, if anything, can be done additionally, in his opinion of the crime scene, is certainly relevant to his investigation of this crime.
Based on the state's answer, my next objection would be lack of foundation. If he wants to establish that Agent Howell could testify about the crime scene at Ms. Baker's home, he needs to bring in.
Wait. I may have missed something because my ears are glitching. Are you telling me that a volunteer firefighter is not a firefighter, Rachel, or did they say he was not a firefighter? I'm confused. Please clarify, Rachel. Thanks.
Testimony that Agent Howell actually went to Ms. Baker's home during this time.
And should I respond to that, Judge?
You may respond if you choose to do so.
Thank you, Your Honor. I believe that Agent Howell has already testified that he reviewed the initial investigation as well as the initial processing of the crime scene. Traveling to Miss Baker's home 22 and a half years or 23 years after the crime had been committed and then testifying to that would not be relevant because it's not the same state as it was on January 19th of 2001. So I think that we have laid the foundation regarding that.
All right, thank you. I'm making a finding that this line of questioning is relevant. I'm overruling your objection with regard to that. With regard to this witness testifying in the form of an opinion, 24-701, which rules regarding lay witness opinion testimony, allows this testimony to be presented. I'm going to overrule your objection. You may continue.
Agent Howell, we were discussing the manner in which the application of water for fire suppression purposes may impact the crime scene and the ability to process it for trace evidence.
It does impact it.
Like, I can ask the question again.
Greatly.
And would that be helpful?
I can continue.
Okay. All right.
Within that crime scene are going to be absorbent materials. There's also going to be building materials that have the ability to absorb moisture and to absorb water. As those materials fall on top of the scene, it becomes layered. You have a burned layer, you have materials that have fallen on top of things, and then you also have singed materials in between within that. And those are going to be wet, and that may affect the transferability of different transferable materials such as trace evidence due to absorption, due to adhesion, and also different materials within that fire scene are going to change due to the effects of heat and fire. Things of plastic will become sticky or may melt. Different things may get consumed and other materials may become absorbent of the water within that scene.
And so particularly as it relates to absorption and adhesion, I want to ask you some background questions and then ask you follow-up questions about those two things. Were you able to review the photographs from Miss Baker's bedroom from the initial crime scene processing?
I was.
Okay. Was there anything about debris that you found significant in your review of those photographs?
Yes, there was ceiling material and there was insulation that had fallen on top of Miss Baker within that scene. And in order to be able to evaluate the body of Miss Baker, those materials needed to be removed. It was a layering process in which things that are on top need to be removed in order to have her visible.
And so when those things on top in this particular circumstance, what were the things on top of Miss Baker?
I believe that there was a piece of ceiling or a piece of drywall that was on top of her, as well as white in color insulation.
And as it relates to absorption and adhesion, did what you see in the crime scene photographs cause you any concerns about trace evidence in it from those two things, adhesion and absorption?
Yes. I recognize that there was the potential for critical trace evidence to be commingled with those materials.
Okay. How would that affect, if it's commingled with those materials, how would that affect the ability for it to be collected and processed at the crime scene?
It would be challenging.
Okay. Let me ask you a question about a particular type of trace evidence. Are hair fibers, or not hair fibers, but are hairs considered trace evidence?
Yes, they are.
Okay. As it relates to hairs in particular, based on your training and experience, would you expect to find hairs from individuals in environments that they regularly visit or occupy?
I would.
Okay. And so let me ask you this. I lost my train of thought there for a second. Let me ask you this about the processing of the crime scene in 2001. Have your tools that are available for crime scene processing changed from 2001 to now?
They have.
Okay. And so can you describe what may be referred to at times as presentism?
Yes. Presentism is one of those things that we try to keep in mind when we are looking at older cold cases. We try to recognize what the capabilities were at that time and what sort of technology they had available to them at that time. That way, when we're applying that critical lens to the case file, to the photography, to the crime scene summary, we're mindful of what the capabilities were then rather than applying presentism, what we can do now to that scene in its documentation. One of the things that we can do is apply modern techniques to evidence that's collected. So we normally try to look at that through that eyes of not bringing today's present capabilities to yesterday's casework.
In your review of the processing of the crime scene in this particular crime, were you able to evaluate the manner in which the crime scene was processed?
Yes.
Okay. And what opinion did you form about that?
I believed that they were innovative in some different techniques, especially with trying to assess and document some potential latent print evidence that was on the thighs of Miss Baker, especially utilizing a chemical developer and a negative lift technique that I honestly was not familiar with until I read this case file and began to educate myself to that process. It was rather novel for the time.
Okay. Did you notice any major deficiencies that you noted or anything along those lines?
No, sir.
Okay. As it relates to the processing of evidence, you mentioned applying modern techniques. Did you go back and rephotograph any of the evidence?
I did.
Okay. In particular, in this case, did you go back and photograph one of the weapons that was used to murder Miss Baker?
I did. I needed some clarification on some things regarding that particular item of evidence.
And what was that particular item of evidence?
There were two photographs that I don't want to say caused me some concern, but just I wanted some clarity on. And it was a knife that was located on the floor next to the body of Tara Baker. Due to the positioning of the knife, I noticed that the exposed side, the upward side, was light in color. Then I saw another photo in the file of a knife being held up that had a dark in color handle. And I wanted to examine that, that knife in order to get clarification as to both sides of that knife, and also thoroughly photograph both sides of that knife so that there was documentation that this was in fact the same knife. To look at that knife in the crime scene photos, it almost looks like a wooden handled knife. But then when you look at it, a knife that's being held up against the wall, I believe there's a white latex glove that's holding up that knife. It looks like a black plastic handled knife. So I wanted to make sure that that was in fact the same knife. So I accessed that knife and I photographed both sides to demonstrate that that is in fact the same weapon.
When you say you accessed that knife, where did you access it?
We went to the Athens Clarke County Police Department in order to be able to access that knife in a quality control environment.
After you accessed it and photographed it, what did you do with it?
We immediately returned it back to Athens Clarke County. We sealed it back up. We left it there at the facility.
Okay.
Well, isn't that interesting? Is it the same knife? That makes me question what's going on with the knife.
Agent Howe, I'm going to hand you what's been marked as State's Exhibit 94 that has already been admitted into evidence. Do you recognize that item?
I do.
And how do you recognize it?
I recognize it in a number of different ways. One is the labeling that is on it. I recognize the Athens Clarke County, their evidence inventory ID on it, as well as their coding that's on it. It has their case number on it. It also has a description of a knife with an 8-inch blade and describes it as charred. It also has a sticker on it from our crime lab, the GBI crime lab, that has our Division of Forensic Science number on it as well as the submission number as number 015. And it also has our GBI evidence property tag, which is a barcode on it. And all of these labels are on this side of the box. There is the Athens Clarke County evidence inventory sticker. There is our GBI evidence inventory sticker, and there is our GBI crime lab sticker here. And it also has seals on it. And where I access the box, there is my initials, my GBI badge number of 189, and the date that I accessed this as 9/14 of 2024.
All right. Do you have a pocket knife with you by any chance?
I do not.
Okay. Your
Don't
Honor,
bring
is
that
it
into
all
the
right
courtroom.
if I hand the witness a pocket knife?
It is.
Thank you.
If you would you please unseal that box?
Let's see. Here we go.
Those inside of the box that you just unsealed, what's contained in there?
There is a sealed brown paper bag in here as well that has the item number listed and documented on there. Again, it has the Athens Clarke County case number on there. It has the item number and the description as a knife. And it also has tape on it from where I resealed this bag when I accessed it back on September 13th of 2024. That's up here on the top.
Okay. Can you unseal that bag, please?
I can.
I'll take my pocket knife back from you. Al. Thank you. Sir, inside of the bag that you unsealed, what is in it?
There is a butcher knife that was located within that that sealed paper bag.
And Your Honor, I'd just ask that Agent Howell be able to step down from the witness stand and just display that a little bit closer to the jury.
You may.
Thank you, Agent Howell. If you could, please take the witness stand again and return the knife back to its original packaging. Agent Howell, as y'all are reviewing the physical evidence in the case and reviewing the case file, is there ever any effort made, you mentioned modern techniques, to determine if there's evidence that it may be useful to resubmit or analyze that maybe wasn't analyzed or can be analyzed in new ways?
Yes, as we document, inventory, and assess the evidence that is in the possession of the Athens Clarke County Police Department in this case, we also discuss if there's anything more that we can do with these items of evidence. And we recognized a few items within that inventory that we believed we could do some additional investigative submissions for testing at our GBI DOFS center.
Okay. Do you know whether or not that was done in this case?
Yes, it was with multiple items.
Okay. And you said multiple items, those were submitted for retesting?
Yes.
Okay. Eventually, when Mr. Edric Faust entered this case as a suspect in the murder of Tara Baker, was it due to result from a national database of DNA?
Yes.
Overruled.
Thank you, Judge. And so after y'all received that information, did you take steps to try and speak with witnesses that were interviewed back in 2001 to re-interview them?
We did.
Okay. And I'm not going to get into every single person, but to your knowledge, were Valerie Lowe and Ashley Peavy re-interviewed?
Yes, they were.
Okay. And who are those people in your knowledge, who are those people?
My understanding is they were roommates of Tara Baker at the time of this incident.
Okay. And was Mr. Chris Melton re-interviewed?
Yes, he was.
Okay. And who did you know Mr. Melton to be?
I believe that he was the boyfriend and in a romantic relationship with Tara Baker
Okay.
at the time of this incident.
And on May 9th of 2024, did you have an opportunity to interview Mr. Edric Faust?
I did.
Okay. And I want to come back to that interview in a few minutes. But first, what I'd like to do is show you what's been marked already, but not admitted into evidence as State's Exhibit 158. I'm showing this to Mr. Cruz first, Your Honor.
All right.
Agent Howell, on May 10th of 2024, did you have an opportunity to collect buccal swabs from Mr. Faust?
I did.
Okay. What are buccal swabs?
Buccal swabs are cells that are located within the cheeks of the mouth. They are very DNA rich and are a common method to collect cells for DNA testing in the preferred method at our state crime lab. And it's essentially get collected by utilizing a swab with a long handle, kind of like a Q-tip, but it's a one-ended Q-tip. And then you swab and you rotate within the inner side of the cheeks in order to be able to collect those buccal cells. They're then packaged in a sterile box. That box is then sealed, and then that box is then resealed into a paper bag similar to this.
Okay. Do you recognize that item that I handed you? States 158, I believe.
I do.
Okay. And how do you recognize it?
This bag is labeled with our GBI evidence property tag. It is BB 68963. And on this is also an evidence sticker that documents the date and time it was collected, who it was collected from, and where it was collected. And this has a description of a box containing 2 buccal swabs from the mouth of Edric Faust. And this was collected on 5/10 of 2024 at 12:05 p.m.
Okay. And Judge, I'd move at this time to tender states 158.
Any objection?
No, ma'am.
It is admitted.
Uh, and when you, Agent Howe, made reference to it have been collected from Mr. Edric Faust, do you recognize that person anywhere in the courtroom today?
I do.
Okay. If you don't mind, please describe where that individual is sitting in an item of clothing or other description.
He is sitting at the defense counsel table. He is wearing a blue and white striped shirt and glasses.
Your Honor, I'd ask that the record reflect that Agent Howe has identified the defendant, Mr. Edric Faust.
Goes to a hiring committee.
Okay.
And then if
Um,
they
after
want,
you
they will call me
collect
and then I
those
interview
samples,
with the
where do you send
department
them to?
people.
We then send them and we submit them to our evidence receiving at our state crime lab facility. And our main center is in Decatur, Georgia. And that is our Division of Forensic Science Laboratory.
Okay. Agent Howe, I want to fast forward again before we rewind back to the interview. Are you familiar with the location at 350 Cooper Road?
I am.
Okay. What significance, if any, does that address have for you in relation to this investigation?
That was our understanding of a residence in which Mr. Edric Faust would stay at.
Okay. And as part of the investigation of this case, was there ever a drone video created of 350 Cooper Road and 160 Fawn Drive?
Yes.
And Your Honor, at this time, I'm going to show Mr. Cruz what's been labeled as State's Exhibit 159. I'm going to retrieve an exhibit real quick before we continue down this line of question. display
to the jury or in front of him.
clip for Agent Howe in order for him to see if he recognizes it?
Yes, but I think you need to do that outside the presence of the jury or in front of him so he can see it.
Yes, Your Honor,
All right.
and I will.
Yes.
Thank you.
Agent Howe, had an opportunity to review some different portions of State's Exhibit 159. Do you recognize what that is?
I do.
How do you recognize it?
I was present during that, and back on January 16th of this year, I was with another agent, Austin Bradshaw, and he flew a drone over the Deer Park area as well as the Cooper Road area in order to obtain footage.
Okay. And is this a fair and accurate depiction of the footage that was obtained on the date that you mentioned?
Yes.
Judge, I move to tender States 159 at this time.
Any objection?
No, Your Honor.
It is admitted.
I move to publish it to the jury, Judge.
May do so.
Hey, Your Honor.
Podium, please, Judge.
Your Honor.
Yes, sir.
This TV turned on too.
Hopefully. If not, yes. There we go.
And publishing States 159. Before we start that, though, what are we looking at here as the video starts, Agent Howe?
This is the front side of 350 Cooper Road, and that is the front-facing side of the house that faces toward, I believe, the east and also the Deer Park subdivision.
I'm sorry, I stopped it just a little bit too early. I'm going to let it start playing again. All right, Agent Howe, camera just zoomed in on one house in particular with a fence surrounding the rear portion of the home. What address is that?
I recognize that as 160 Fawn Drive.
And where was it that Miss Baker was murdered?
That was at 160 Fawn Drive.
Okay. Back in 2001, you already testified you had an opportunity to review the crime scene photographs. Is that right?
Yes.
Okay. That fence that appears around that property at that time, was that in existence in 2001?
That was not.
Okay. And I'm going to put up what's been marked as State's Exhibit 37 and already admitted into evidence as a overhead image of the Deer Park neighborhood from 2001, shortly after Miss Baker's murder. So if we could switch to the Elmo, please, Mr. Terrell. On State's Exhibit 37, if you could, please indicate by drawing a circle where 160 Fawn Drive is located.
And that's on, is this a touchscreen here?
Yes.
Okay.
Thank you, sir. And now, if you are able, please draw a circle around where 350 is located. And Agent Howell, are you aware of the distance between 350 Cooper Road?
Yes, I measured that distance as 585 feet.
Okay. And if we could go back to the podium connection at this point. Thank you. And I'm continuing to play States 159 at this point.
Sorry, these are just drone footages of the area.
Agent Howe, the drone is looking back at a residence from 160 Fawn at this point. What is the residence that it is looking back at?
I recognize that as 350.
Okay. Your Honor, that concludes the display of State
Good.
Exhibit 159 for the jury at this time. And Agent Howe, if we could go back to the Elmo just briefly, Mr. Terrell.
I think it takes just a second.
Agent Howe, obviously in that drone footage, there were some trees and things along those lines. In looking back, I've displayed State's Exhibit 37 again. What is the nature of the trees and other foliage between 350 Cooper Road and 160 Fawn Drive back in 2001 as compared to the time at which that drone footage was taken?
Yes, our understanding at the time of this incident in January of 2001 was that this was a new development. This was still in the process of being developed, that the land had been cleared and there's very minimal trees that were present. When we fast forward to today, there's overgrowth, there are trees present. And also 160 Fawn Drive has also changed in terms of additions being put onto that residence.
Agent Howe, I'm going to hand Mr. Cruz what I marked as State's Exhibit 160. I'm going to hand you, sir, what I marked as State's Exhibit 160. Do you recognize State's 160?
I do.
Okay. What do you recognize it to be?
This is the interview video with Edric Faust.
And did you place any markings on this exhibit's tag?
I did. I initialed it.
Okay. And what did you initial it to signify?
That I had previously seen and reviewed that item of evidence.
And were there any, did it appear to be a fair and accurate recording of your interview with Mr. Faust on May 9th of 2024?
Yes.
Judge, I moved to tender State's 160 and publish portions to the jury.
All right. Any objection, Mr. Cruz?
No, ma'am.
All right. It is admitted. And before you publish it, Mr. Yalmanchilli, we're going to take a restroom break. It's 11:15. We'll take a 15-minute break, and we'll be back on the record in 15 minutes. If you'll go into the jury room, don't discuss the case. We'll see you shortly. Thank you.
Okay, I can zoom, but I don't know if this is the case. I don't know if it's true or not, but based in North, there's a post. Nancy Guthrie disappearance is growing more complicated. A man is now being detained near Mexico border and his home is being searched. What did he tell investigators and why did he draw attention? 30 plus photos from the case, including potential suspect. So I don't know if that's actual true or not. I'm not going to sit there and validate that at this point, but that is a possibility. I'm going to do my research. But guys, y'all keep the families in prayer. I will be doing a dive into this. But in the meantime, let's get. Oh, I got to go feed Monkey Butt. When we get live again, I'll go feed her.
I want to go on the record just for a minute. I want to address our media, if I could, one more time.
Oh, crap.
Just be really clear about the Rule 22 that the court has provided to all of our media. There have been some concerns about, that I've raised earlier with you all, about the jury being identified in certain ways, whether it has happened completely like that or just that there are concerns. But there are concerns about that. And I want to make sure that all the media who have been provided a Rule 22 permission in this court to understand that there is to be no identifying at all of any of the jurors. And that also includes reposting comments about this trial and identifying any jurors by their facial expressions or their dress or their note-taking or not note-taking. Any of those comments are impermissible under Rule 22, and it is related directly to two things, to security issues and also to concerns about influencing the jury outside of this courtroom. And so I'm going to ask the media to definitely pay specific attention to the rule that the court provided and to refrain at all costs from identifying any individual jurors in any way. A comment about the jury as a whole, that they arrived at 9 o'clock, that they couldn't hear the evidence or something to that effect is not what I'm talking about. I'm talking about individual comments about individual jurors and their behavior. That is prohibited. All right. Thank you very much for your cooperation. All right. Is the state ready to proceed?
State's ready, Judge.
Is the defense ready?
If it's allowable, Your Honor, I would ask for 5.
Mistrial.
Up to the honorable court's discretion.
Well, I think we really need to get started. Is there a particular reason you need 5 more minutes?
I'm just trying to find a single site, and that's it.
Okay, I'm going to let you do that while the state gets started. All right, you may bring the jury in. Thank you.
Thank you so much, Angela. Yes, I'm going to be covering all of this tonight when I get back from my Wednesday meeting. I'm going to come live and cover all this.
Thank you, Your Honor. Agent Howe.
I've had people ask.
Before we broke, I believe we had just tendered into evidence State's Exhibit 160 as a recording of the interview that was conducted with Mr. Edric Faust on May 9th of 2024. Who was present for that interview?
I was present. Special Agent Liz Bigham was present, and Edric Faust was present for that.
At the time that the interview was done, had Mr. Faust been placed under arrest?
Yes.
Okay. And Your Honor, for the record, at this time, I will seek to publish in chronological order the timestamps that I'd previously mentioned to the court and defense counsel.
All right, you may proceed.
And I'm starting at 6:03:55.
Hey, how are you? Good. Are you Miss Faust?
I am.
Hey, I'm Liz Bigum. I'm with the GBI. This is Jeremy Howell with the GBI. You want to take those off right now? We need to sit and talk to you and do some things. Are you going to act right? Are you sure? Okay. Do you my handcuff keys back in there, so I can go grab it. Do you have one on you? Okay. Can you use some water or anything?
I'm cool.
You sure? You use the restroom?
I'll just use
I'm sorry?
I use the restroom.
Oh, you just use the restroom. Okay.
Let's see, I think I got the right key for these. Right, let's go down this a ways. There it is. Okay. Sorry, I'm not going to key for that. There you go.
Here's that for you, just in case you want something.
There you go.
All right. So there's a little bit of paperwork we gotta do first, and you can get some information from you, obviously name and all that stuff. And then we'll kind of go over there. Go ahead. So you've got, I think it's about 9 warrants that we've got for you today. I'll explain everything to you. Let me get this filled out and stuff, and then we'll go over everything together, okay? I mean, obviously, we're gonna want to talk to you about this stuff, and we can kind of go into all that, but we gotta get through this first. All right? It's Edric or Edric?
Edric.
Edric,
Yeah.
E-D-R-I-C-K?
Correct.
And what's your middle name?
Lamont.
L-A,
M-O-N-T.
all right, and F-A-U-S-T?
Correct.
How old are you, Mr. Faust?
I am 48.
Are you sure? Okay. And what's a good home address for you?
My home address is, well, I got a P.O. box.
What's like your physical home address?
350 Cooper Road.
350 Cooper Road?
Correct. Yeah.
Okay. That's in Athens?
Yes. 05.
30605?
Yes.
Okay. Okay, and how hard are you going to school, Mr. Faust?
I graduated from high school diploma.
High school diploma?
Yeah.
Okay.
See the shows? Actually, I went to see the show, but I went back to continue. I got a diploma in another school.
Okay,
Got another further down the road.
gotcha.
All right, you can read and write, I'm assuming. Okay, so let's go over this together. All right, it's 6:06 now. So today is May 9th, 2024. The time is 6:06 p.m. and we're at the, I wrote ACCPD, but Athens Clark County Police Department. Your name is Edric Lamont Faust, and you are 48 years old. Your address is 350 Cooper Road, Athens, Georgia, 30605, and you completed the 12th grade in school.
Yes.
You know that Liz Bagum, which is me, and Jeremy Howell over there are special agents with the Georgia Bureau of Investigation.
Okay.
All right? You have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you're being questioned. If you can't afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish.
Okay.
And you can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand all of that?
I do.
Okay. And you understand your rights and having these rights in mind, you're willing to talk to law enforcement officers, which are Jeremy and I. You've not been threatened. Has anyone threatened you in any way, shape, or form in law enforcement? Nobody threatened you? I know we weren't there when they arrested you, so I just want to make sure that nobody out there threatened you in any way. You've not been promised anything. Has anyone ever promised you anything in reference to this? And then if you've been forced in any way to answer any questions or make any statements, maybe decide what's your name, whatever. Okay. So if you're willing to talk to us, you can sign right there. I'll sign underneath you, and Jeremy will sign underneath me. Thank you.
Yeah.
So let me just get a little bit of information from you first. Obviously,
And I'm pausing the video briefly at 6:08:12, Agent Howe. And I'm going to show Mr. Cruz what's been marked as State's Exhibit 161, Your Honor. And Agent Howe, I'm going to want you to take a moment and let me know if you recognize what that is.
I do.
And what is it?
This is the waiver of rights form that was administered during this interview with the information on it, as well as the signatures of Mr. Faust, Liz Bigham, and myself.
All right. Does that appear to be a true and accurate copy of that waiver of rights form that was executed on May 9th of 2024 during Mr. Faust's interview?
Yes.
Okay, Judge, I moved to tender 161 at this time.
Any objection? It is admitted.
And Your Honor, I'm going to continue playing the video for 6:08:12. But before I do that, Agent Howell, just to get some orientation about what we're looking at, where did this interview take place?
This is an interview room that's located at the Athens Clarke County Police Department's facility, their main police building that's on Lexington Highway.
Okay. Obviously, we heard the reading of the form and it's been admitted into evidence. Based on your observations of Mr. Faust, did it seem like there was anything that was preventing him from understanding what was happening or anything like that?
Not that I was aware of.
Okay. As the interview progressed, did he seem to understand the questions and respond to them?
Yes.
Okay. And so I'm going to continue playing now, Judge.
You got Cooper Road. How long have you lived at Cooper Road?
Shit, I've been in Cooper Road about 40 years.
40 years? Okay.
40.
40?
40.
Okay. Do you own that house?
No.
Okay, who lived there? Or whose house was it?
Actually, it's my stepmom. She passed away a month ago.
Oh, no, what happened?
She had a lung cancer or something like that.
Aw.
This your stepmother, you said?
Yeah.
I'm sorry.
And what is her name?
Her name was Geraldine Hughes.
Geraldine Hughes? And she passed away months ago. So are you still living there? Did she own it?
Yeah, she owned her own, yeah.
Okay. Are you still living there?
I'm kind of like slow. I've been like slow. I've been living with my cousin here and there. So,
Where does your cousin live?
I've been living in Overthorpe County.
Oh, okay. Where's that
And Overthorpe, and Maryville in Santa Claus.
Standing across from Mary Bush Road? Where do you lay your head at night?
Well, I've been really just living here and there. I've been here and there and just girl house over here and over there.
Over here and over there, the girl's house.
Yeah.
All right. Where does the girl live? Somewhere you don't want to talk about?
No.
That's fine. We don't have to. And what's your date of birth?
9685.
Okay. And you're employed, I'm assuming, at Athens Finest?
Correct.
Is that your business, or do you just work for them?
My business.
It's your business? What do you do there? Besides mobile detailing, pressure
That's
washing?
what I do.
Pretty much that?
Cool.
Do you have like regular work, or is it just contracted work here and there?
I do regular work, whatever. I just work.
Okay. All right.
How long you had that business?
I've been in business myself I've been in business for myself, working on my own for like 4, 5, 5, 6 years.
Okay.
Okay.
And Judge, I'm stopping as we had discussed. Oh, I'm sorry. I stopped about 10 seconds early.
What's your number to get you?
This is?
That one's your number?
Yeah.
706-612-6808. That's the best number to get you?
Yeah.
Is that your cell?
Your Honor, I'm stopping at 6 minutes, 6:10:20 p.m. hour, minute, second. And I'm moving forward to 6:14:01.
Okay, that's on them, y'all. They slowed it down. Why? Okay, playback speed normal. Okay, that's all on them. I have no idea. My monkey is tearing it up. I gave her something to play with, and I mean, she's tearing it up.
Who lived you with Cooper, or who lived at Cooper Road with you?
At Cooper Road. Actually, back then, 20 years ago, May 28, 2003.
No, 23 years ago. We're talking about 2000. It was obviously misused, right?
I was living with her, yes. But
Okay.
I don't know what relationship I was in, who I was with back then.
Okay.
Really? I didn't
So
hear
did you
that.
live there?
Interesting music.
Yes.
Did you have any brothers or
By
sisters?
Brian?
My brothers and sisters.
Okay.
My dad was alive back then, yeah.
But was he at Cooper, or did he live in Oakland?
My dad has been around. He's just been around. He got left,
Yeah. Okay. Who else lived in the house with you? Who lived with y'all back then?
This far as I know of.
Just y'all two?
Yeah.
Okay. And she was your stepmama?
My stepmom.
Where's your real mama?
She passed away 6 years ago.
Oh, okay. You weren't ever really close to her. You were close to your stepmama?
Actually, I've been cool with my stepmom. She raised me with.
And Your Honor, I'm stopping at 6:15:05, and we are going forward to 6:50:30.
Wow, that's interesting. Taken forever for this video from yesterday to download, but they're so long. So as soon as it downloads, I'll be trimming out that section. I don't know why they keep doing this.
I'm sorry, Judge. It's not a very precise slider. So
Why are you apologizing? It should be
Were you there
precise.
when they were building it and stuff like that?
Yeah. I was in that area. I'm always in that area. I go in that area every day.
Do you really?
Yeah. I call it my home. That's considered my home.
Okay.
Yeah.
Do you physically live at Cooper Road anymore?
Oh, you can go there right now, and everybody will know me. They
No,
know.
I meant in the house, like at 350.
No,
you physically live there anymore. Okay.
no.
Did it get passed down to you? Or,
Well, my stepmother passed away.
okay.
When she passed away, when she got sick, she told me she didn't need me anymore. Her niece lived in Rock Spring. She ended up getting the house. She bought the house from her, and she ended up moving up to Willow Miss across the street over here.
Okay.
And she lived over there when she passed away.
So nobody in your family lives there?
It's her niece live in the house right now.
Okay.
Yeah.
Okay.
And she just passed.
Okay.
Yeah.
Okay. So when that neighborhood was being, or development was being built, I guess, did you ever go walk around there, or what was that built for, I guess?
I don't know.
Was it mostly like college students, or was it regular people, older Athens people, old
Back then it
people?
was real settled, but now it's not like that anymore. It's like real, like, right now it's like, oh, damn, the ghetto, to be honest with you.
Oh, is it really?
Yeah, it's pretty rough over there now. Back
Why is it rough over there?
it seems like everybody that got pulled from the other side of town, they start getting rid of like housing, the projects and all that. They give them vouchers and they start moving over on this side.
Oh, they did?
Yeah.
Okay.
So it's not like it used to be. It used to be real quiet. So.
Okay. So back then, who was moving in there? What was it primarily?
I say college students and probably some kids. I'll say that because you didn't really see a whole lot of black people in that area.
You did not back then?
Nah.
Okay.
What was there before they built all that?
It was wood. It was old car. All this on Lexington Road, Walmart, everything on Lexington Road was nothing but wood. There's a Lord Stevens, there's a church, Lord Stevens, Walmart, all that was wood when I was a little boy.
You seen some change.
I really have. And it's, I mean, from there's another house over here in this neighborhood, all this land over here where this Dollar Tree and the skate park and all that. All that was never wood back in the day. Wow. Yeah, all that wood.
Judge, I'm stopping at 6:53:05, and we're moving forward to 7:02:45.
Were you ever dating anybody else around that time on the side or quietly?
I ain't gonna say that. I ain't gonna say that.
I'm not gonna go talk to them.
I mean, I ain't gonna know.
I just wanna know.
I ain't no.
And Brandon was the primary one, right?
She was primary,
10 years, okay.
No, I don't do no
But what about anybody else, like anyone at Walmart or ConAgra or the perfect polish? I keep wanting to call it Sparkle.
I don't know, man. I don't, let me tell you something. I don't have some females in my day, so.
It sounds like it. It sounds like it.
Yeah.
But were you juggling any other females around that time? See anybody on the side?
I probably was. I don't have a lot of females in my day.
Okay. Do you date white girls or do you date black girls or does it
I
matter?
have dated white chick. I have dated one white chick, but it didn't work out.
One white chick?
Yeah.
Who is she?
Her name was Rita Spears. And that was she's from where Rita from? She's from Carnesville.
How'd you meet her?
I met her at one night at the bar.
Why didn't it work out?
Because she bipolar and she wanted me to be with her and call her all the time.
Oh, okay.
And she lived up in Carnesville, Franklin County?
Yeah. I don't really, I mean, I don't have no ethic about females, the race, no color, nothing like that.
All right.
I talk to everybody. I'm cool with everybody.
Mhm.
You can go down here right now and ask anybody about me when it comes to communication. I communicate because that's my, I have a business.
Sure.
I don't mess around, man. I mean, I just treat everybody the same.
Okay. Did you ever date anyone over in that Deer Park area?
No.
Any college students, anything like that?
I know nobody over there.
You didn't know nobody over there?
Mm-mm.
Never made friends? You just didn't talk to everybody?
I mean, I talk to everybody, but that was my cup of tea to go over there and deal with those people. Those people up across the street. I ain't going to nobody over there.
Why not?
I ain't know nobody over there. That wasn't my thing. I wanted to see my stepmama
Yeah.
or whatever. That was it. I mean, that's a neighborhood that just came up. I don't know anything about that neighborhood.
Okay.
And I don't have no dealers over there, period.
Anybody from over there ever come looking for you? Just to be friends with or hang out with?
Mm-mm. Back then, man, there was a play everybody like, man, it's just a play that came with this coming up. And everybody feel like it's high over these expenses. Anybody going over there, so.
That's how it was kind of perceived?
Yeah, everybody go over there.
Okay.
And Judge, we're stopping at approximately 7:05:40, and we're moving forward to 7:08:35.
Guys, I got to run right down the street, literally a half a mile, and then I'll be right back. I have to pick up something. I can't wait. So I'll be back. It's going to keep running. I'll be monitoring. See you in a minute.
They are for a myriad of charges.
And I'm sorry, Judge, I think I started the sound a little late. I'm going to back up again to 7:08:35.
we've got these warrants.
Mm-hmm.
They are for a myriad of charges that range from arson to murder.
What?
Mm-hmm.
For me?
Mm-hmm. And that's what you're talking about, this incident back in 2001. I think there's 9 different warrants, and that's kind of about this, get your side of the story, you know, kind of hash everything that happened, and you know, obviously I think you can pick up on the fact that it involves that area, that park area or whatever.
Yeah.
But in my opinion, I mean, you can see that I've done research, right? Like, Jerry and I know, we know about you and stuff like that. But when we're talking about that and we're talking about these charges, there's got to be kind of an explanation as to why you're there, right?
Yeah.
And that's kind of what I'm trying to talk to you about.
Yeah, okay.
So tell me about why you would be there in that deer park area back in 2001 and kind of, you know, engaging in all these sorts of things at one of those duplexes.
I never, that spot over there, that's a place I never been to. I started going there throughout the years, like, when people thought, other people, when we started moving in, then, but back in the day, the only reason I go like in the evening time, and it's every blue moon, I gotta get my bike in the evening time, like 3 or 4 o'clock in the evening, I may ride through the whole, you know what I'm saying, ride from
Like that round,
the whole thing, all of that. I don't put it on there. I ain't got no business over there. They were my church. My church was in our neighborhood where we used to be, because everybody in the neighborhood.
On the other side, the whole Deer Park,
all the way on East Meadow and all the way in Morning View.
Okay.
I got no business over there dealing with that over there, but that ain't my cup of tea. They ain't gonna drink over there, and I don't drink with them, so we up here drinking. If one of my cousins gonna come here and pick me up, and we go over to us ride out, they'll say, I don't have no business over there fooling them people that they ain't doing that to me.
And you said that you rode a bike?
Every once in a while, I may about.
Yeah,
if I was over there, but I didn't deal with that sex.
Was you in a walk?
No, I don't have no business over there. This is my neighborhood right here. I don't know about people over there.
The prosecutor, right?
Exactly. I don't have no business over there, period.
And you said around 3 or 4 in the afternoon?
I said, yes. I went over there. If I was about that, I would go in. But I have no reason going over there and messing with people, period. No reason whatsoever.
And Your Honor, we're stopping at approximately 7:11:15, and we're going to move forward to 7:11:45.
No, I don't do no walking over there for what? I ain't got no business over there walking. No.
Well, you would ride your bike around though.
I mean, I said, if I went over there, if it just so happened back in the day, if I just rode my bike, I would ride around and see, I ain't got no business walking over there. If some people were jogging or walking, I ain't have no business singing into them and nothing.
Okay.
I don't, that ain't my gig over there. If I went anywhere, I probably would go to back then, I would go to the hood in the Aston Garden. That's probably where I'd be at.
Would you have cut through Deer Park to get to Aspen
No,
Garden?
it's not that way.
It's the other way?
Different direction. I don't go that way. I don't have nothing to do with it. People up here. I go over in the hood and kick it, but I'll be in my neighborhood. I ain't got no business over there dealing with them people. I ain't getting nothing to. I don't even know nothing about them. I ain't finna mess with them.
Okay.
Period.
Okay.
So I mean, I guess one for me.
Mhm.
Yeah. So I'm gonna go jail.
Mhm.
Really?
They told you were under arrest.
I mean,
that's not a new revelation. They told you were under arrest.
that's a murder.
It's for
Do you remember any kind of incident that happened back then?
Man, I don't even deal with over there.
I understand.
No.
You don't remember seeing some police activity over in that neighborhood back in 2001? Kind of a big deal.
just for a while too, I think,
Yeah.
like days and days.
You don't remember anything happening back there?
Let me see. Cause I used to come over there and see my stepmama, but I ain't really, deal around too tough in it.
Okay. It's kind of like one of the biggest deals that's happened in Athens.
A murder?
Yeah.
Mm-hmm.
Oh, some girl.
Did you know her? No connection to her?
No. I don't know. I never saw it. The only time I see that, the only time I seen that was in the newspaper. I ain't never seen it or nothing else about that girl. I don't even know her. I don't know nothing about her.
You know what she looks like?
Sorry.
Oh, no, right. No.
You've never talked to her?
No, never. No.
Okay.
Don't even know her. Don't know nothing about her at all. All I know is that she was a law student at the UGA, and she was on Farm Drive.
Mm-hmm.
And throughout the years, I know that right there they got that's where the rent office is right now.
Oh, yeah.
Yeah, that's where my brother stayed right beside it.
Your buddy stayed right beside us?
That was after the fact that when we started moving in, when black people started moving in, my papa stayed right beside him. Right beside the actual building. This happened like in 2017 or 18. Okay. Not no recent thing. You know?
Oh, okay.
No, not no recent.
Okay.
Did you know any of her roommates?
I don't know.
Did you know any of their boyfriends or anything like that?
No, nobody over there, period.
Did you ever go over there to buy alcohol?
No.
Anything like that?
Bro, listen, I don't know nothing about those people over there. I don't know nothing about that. But they said that happened.
And Your Honor, I'm stopping at 7:15:05 and moving forward to 7:16:14. And Agent Howell, kind of just before this portion of the video that we're about to play, had you asked Mr. Faust a question about his awareness of a national database of DNA?
Yes.
DNA?
Yeah.
My DNA? Man.
It's been a long time. We've made so many advancements and things. If you can help us understand why your DNA is in that house, help us. I don't want to put it. Help us. I'm here to exonerate just as much as I am to hunt.
Y'all come on, take a little deal.
And Agent Howell, in response to your request for Mr. Faust to help you with an explanation regarding his DNA, what was his response?
No explanation was provided.
Okay. And I think that's all I have for you about this interview. And so, Your Honor, if I could have just a moment to.
You may.
Agent Howell. I'm going to show Mr. Cruz what's been marked as State's Exhibit 162. Agent Howell, I'm going to hand you State's Exhibit 162. Do you recognize what State's 162 is?
Yes.
All right. How do you recognize it?
I recognize it by the labels that are on the exterior of the envelope. It is item number 10 in Athens Clarke County Police Department's custody. It is described as a bloodstained card for Chris Melton. It also has a GBI barcode on it, evidence property tag CC 36694. And it also has our GBI DOFS report number, which is 2001-1002454, and is submission item number 27. And again, it is labeled as a bloodstained card for Chris Melton.
Okay. And so have you encountered that item at any time previously?
I have.
Okay. Can you explain to the jury, well, when you encountered it, is it in substantially the same condition as when you encountered it initially?
Yes.
Okay. Judge, I'd move to tender the exhibit at this time.
Any objection?
No, ma'am.
It is admitted.
Okay. Just to clarify though, were you involved in either the collection or observation of collection of blood, the creation of the card, or any of the testing that occurred at the GBI lab?
I was not.
Okay. What was your interaction with that item?
My interaction with this item was to collect this item, transport this item to the state crime lab, and submit this item to our state crime lab.
Okay. And do you have any direct knowledge of anything that was done with it at the state crime lab?
I believe it was compared to some swabs involved in this case.
All right. And that's all I have about 162. Your Honor, I don't have any other questions for Agent Howell at this time.
Cross-examination, Mr. Cruz.
Good afternoon, Agent Howell. My name is Attorney Ahmad Cruz, and I have the privilege and honor of representing Mr. Edric Lamont Faust. You've had opportunity to watch that video before, is that correct?
Yes, I have.
And we could both agree that you watched it again in court and you heard it again in court, is that correct?
Yes, sir.
Okay. In regards to speaking to Mr. Faust about the death in Deer Park, would you agree that Mr. Faust's response, as you heard here today in court, is the only time I seen that was in the newspaper?
Yes.
Okay. And he also continued, I ain't never seen that or nothing else about that girl. Is that correct?
Yes.
At that time, did anyone show him a photograph?
No, sir.
At that time or any time during the interview, did anyone tell him Ms. Baker's name?
No, sir.
I'd like to show you what I'm going to mark as defense exhibit 49, 50, and 51. And just to make it clear for the record, and from the video, Mr. Faust said he'd only seen one newspaper article about it. Is that correct?
I believe so, yes.
Your Honor, may I approach the witness?
May?
And let the record reflect that I've shown the state what has been marked as defense exhibit 49, 50, and 51.
Thank you.
Y'all are bad.
Recognize the photographs?
I do.
That photo? And do you recognize those documents? Let me ask you that. Have you seen those documents in your case file?
Yes, I have.
And follow up to that, you reviewed your entire case file, is that right?
I have looked through the entire case file.
Okay,
I'm familiar with the contents of the case file.
okay, perfect. Do you recall seeing those documents in the case file?
I believe seeing numerous newspaper clippings and articles in it. This one specifically, I don't recall, but I do recall seeing numerous newspaper clippings in there.
Sure. And the question I have for you is about the photo. Would it be fair to say that the photo of Miss Baker in those documents that I provided to you is the photo that's mostly used when it comes to public information about Miss Baker's case?
I would agree with that.
Your Honor, I would move to, and just to make sure you are familiar with those documents, you looked at those documents. Is that correct?
Yes, sir.
Okay. Are those fair and accurate depictions of the documents that were in your case file?
I believe so, yes.
Have those documents been altered in any way?
I don't believe they have.
Your Honor, I would now approach. Your Honor, I would move to introduce Defense Exhibit 51, Defense Exhibit 50, and Defense Exhibit 49 into evidence. And I would ask to be able to publish same to the jury.
Any objection?
As to the images, no, Your Honor. I didn't read the articles themselves, but I don't think that the contents of the articles themselves should be published to the jury.
I think that's correct. I think we need to redact them before you publish them, but during a break, I'll let you do that and I'll allow you to publish them.
Yes, ma'am.
All right. But they are admitted.
Yes, ma'am. Thank you. And you would agree in your statement to Mr. Faust, you never told him that his DNA was in Miss Baker's body. Is that correct?
Did not have that opportunity.
Okay. You told Mr. Faust to explain why his DNA was in the house. Is that correct?
Yes.
Outside of her body being in the house, you would agree that Mr. Faust's DNA was not in the house. Is that fair to say?
Mr. Faust's DNA was inside the house.
Outside of her body being in the house.
Her body was inside the house.
But for her body, Mr.
Semantics.
Faust's DNA was nowhere else in the house. Is that correct?
I would agree with that.
Now, you asked Mr. Faust was asked about dating, and I believe the word, and if I am wrong, please forgive me. But I believe he was asked about dating, I'm gonna use a different word, white women. Is that correct?
Yes.
Okay. And Mr. Faust's response was that he had only dated one white chick, correct?
Yes.
And I want to emphasize the language you asked him, or he was asked.
Lawyer, if you are repeating the words that somebody else said, okay. But otherwise, I take offense as to being called a chick. That I take offense to. Do not refer to us women as chicks.
Specifically about dating. Is that fair?
Yes.
And Mr. Faust made clear that he doesn't discriminate when it comes to dating. Is that fair?
That's my recollection.
Okay. I also want to talk about the first portion of the interview that was played. I believe the state stated on the record that they stopped at 6:08:12. Would you agree that from the first portion, the very first clip that was played for the jury, Mr. Faust had already been advised that you all had non-warrants for his arrest?
Yes.
The second clip that was played in regards to the conversation with Mr. Faust. Mr. Faust had been advised at least twice by the time we got to the second portion of the state's clip that you all had 9 warrants for his arrest. Is that fair?
Yes.
My final question for you is on May 9th, this interview was conducted. Is that right?
Yes.
And May 10th was the date that you all collected the buccal swabs.
The buccal swabs, yes.
How about a 5-foot pole? Will you touch chick with a 5-foot pole? 15-foot pole? What's the size pole will it take for you to touch chick? These are little magnetic
The
bookmarks.
arrest warrants were obtained on May 9th as well before the interview. Is that correct?
Yes.
There's the book. And then they get a little bookmark. Really? That's interesting.
Just make sure I have this accurate. Interview takes place on May 9th. Arrest warrants secured on May 9th, but arrest warrants were before interview. Is that fair?
Yes.
Okay. And then after that, May 10th, buccal swabs.
The buccal swabs were obtained on the next day, yes.
Thank you so much. Those are the questions that I have for you.
Thank you.
Any redirect of this witness?
He's like, can I get off the stand now,
Your
please?
Honor.
I've been
You
here
may
for a
step
day
down.
and a half.
All right, it's 12:30, ladies and gentlemen. A very good time for a lunch break. I'm going to send you to lunch and ask you to return at 1:45, so an hour and 15 minutes. As I've said throughout this entire time, please, of course, don't discuss the case with anyone. Don't do any independent research on your cell phones or computer or any other manner. Don't go to any of the locations, of course, you may have been hearing about. Other than that, enjoy your lunch. We'll see you back here at 1:45. Thank you.
Your Honor, if the jury, it doesn't need to be in front of the jury.
Um,
Defense ready for the jury to come in? All right, thank you. You may bring the jury in.
You got it wrapped for the moment. And
Welcome
we're
back,
waiting for
ladies
them
and
to get their
gentlemen. We are
sound back
ready
on.
to resume the
There we go.
trial of State of Georgia versus Edric Faust. SU 24 CR 0547. Is the state ready to proceed?
Ready, Your Honor.
Is the defense ready to proceed?
Yes, ma'am.
All right, you may call your next witness, Mr. Bolden.
Thank you. State would call Zakira Sims.
Could you get Zakira Sims, please? Thank you.
Yeah, she did. Hello, Miss June. Good to see you.
You can go. Yeah, go. You can go ahead and have a seat. Ma'am, if you could please raise your right hand. Do you swear or affirm that your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
And if you could start by stating and spelling your name for our court reporter, please.
It's Zakira Sims, spelled Xykira. Last name Sims.
And how are you employed, ma'am?
I'm employed with the Georgia Bureau of Investigation, also known as the State Crime Lab, and the Division of Forensic Science.
And what is your position at the State Crime Lab?
I am a forensic DNA analyst.
How long have you been employed by the Crime Lab?
Over 4 years.
And based on your time at the State Crime Lab, are you classified as a senior scientist?
Yes.
Can you please explain what your job entails?
I receive evidence from state and local agencies in which I perform DNA analysis on. I also interpret data as well as generate reports that summarize my findings and conclusions. I also testify in court when needed.
Can you talk a little bit about your educational background?
I received a Bachelor's of Science in Forensic Science, as well as a Master's of Science in Biology from Western Carolina University. I also went through in-house training at the GBI, in which we were given lectures, PowerPoints, and literature reviews that outlined the entire DNA analysis process. We also were given mock case samples in which we performed the DNA analysis process on. We had to take and pass several written, oral, and practical exams. And then I went through a phase of supervised casework.
Ms. Sims, just briefly, what is DNA?
DNA stands for deoxyribonucleic acid. It is the genetic blueprint of life. You receive half from your mother, half from your father, and DNA is unique to each individual with the exception of identical siblings.
Can you explain briefly how DNA testing is performed?
We start by taking a cutting of a sample, placing it in a tube with chemicals to release any DNA that may be on that evidence item through a step called extraction. We then figure out how much DNA is in that sample through a step called quantification. We make many copies of specific regions of interest along the DNA, and then we separate and detect those copies in order to establish a visual representation of your DNA known as a DNA profile.
And is what you've just described the well-established DNA analysis method that's been around for approximately 25 years?
Yes.
I'll do it in a minute.
Certified, ma'am?
I am not.
Okay. And are you a member of any professional societies?
I am not.
Have you testified before in court?
I have.
Approximately how many times?
13.
Okay. And are those in various superior courts throughout the state of Georgia?
Yes.
And have you been qualified as an expert in those times that you've testified in court?
Yes, I have.
Your Honor, at this time I would move to tender Ms. Sims as an expert in forensic biology and DNA analysis.
Any objection?
Our objection from a prior hearing, but we respect the Honorable Court's ruling. We would have the same objection.
The same objection. Thank you. I'm going to overrule the objection and admit this witness as an expert in forensic biology and what was the other one that's
DNA analysis, Your
in
Honor.
forensic biology and DNA analysis. You may continue.
Ms. Sims, before we get into DNA testing that you did in connection with this case, I want to kind of fast forward a little bit to August of 2024, in that time period, were you asked to create cuttings from certain pieces of evidence that had already been submitted to the crime lab?
Yes, I was.
And may I approach the witness, Your Honor?
You may.
All right. Ms. Sims, I'm going to hand you first what has previously been marked or entered into evidence as State's Exhibit 25 and State's Exhibit 143. Are you already got your gloves on? Okay, excellent. Take a look at those. You recognize those items, ma'am?
I do.
And so essentially is State's Exhibit 143 an envelope containing cuttings that you took from State's Exhibit 45 and then sealed into an envelope?
Yes.
You recognize that by the unique DOFS case number as well as your initials all on State's 143?
Yes, the unique Division of Forensic Science case number, as well as my initials and date.
I'll take those back and swap them out. Same question here. I'm handing you what's been previously tendered into evidence as States 26 and States 144. I ask you the same question. Do you recognize those, ma'am?
I do.
And just as before, Ms. Sims, did you take the contents of States 26 and make cuttings of that, which you then placed into States, I believe, 144?
Yes, I did.
And just as before, do you recognize that by the unique Division of Forensic Science case number as well as your initials and date of August 30th of 2024?
Yes, I do.
So now I do want to go back to earlier in 2024. And I want to say February or March of that year, was certain DNA analysis requested on the case involving a victim by the name of Tara Baker.
Yes, our first service of male DNA screening.
Okay. And can you briefly describe how that testing was performed?
We took a cutting of the swab submitted within the kit. We placed it in a tube with chemicals to release any DNA that's present. We then figured out how much DNA, specifically looking for the presence of any male DNA within that sample.
And I don't want to get too in detail about it, but what was the testing kit that you used to screen for the presence of male DNA in this case?
We used the Quantifiler Trio quantification kit.
Okay. And if you know, ma'am, how long has that particular kit been used by the GBI Crime Lab?
The GBI validated in 2017 and started implemented it in 2017.
And Ms. Sims, is that particular kit more sensitive than testing that existed back in 2001?
Yes, it is.
And when you used that particular kit, did you do so on 3 separate items that had been submitted from the sexual assault kit collected at the time of Miss Baker's autopsy?
Yes, I had 3 items. I had item 2B, rectal swabs. I had item 2J, oral swab B, and then 2I, oral swabs B, and then 2J, oral swabs A.
And can you please tell the jury what, if any, results you had when you screened for the presence of male DNA in those 3 pieces of evidence?
Those 3 pieces of evidence all revealed the presence of male DNA.
approach, Your Honor.
May?
My hand was from Washington State 1-3. Do you recognize that, ma'am?
I do. It is the male DNA screening report that I generated.
Okay. Does that report accurately summarize the results of the male DNA screening test that you just described?
It does.
163.
Any objection?
No, ma'am.
It is admitted.
Okay. Moving forward, after you had determined that there was an amount of male DNA present in each of those items, 2B, 2I, 2J, what was the next step that you undertook, ma'am?
All three of those pieces of evidence items went on to a DNA typing request service.
Okay, and if you could briefly describe how that test is performed.
We took a cutting of each of those evidence item samples. We placed it in a tube with chemicals to release the DNA. We used a specific DNA extraction method that allowed us to separate into two fractions, one of which is non-sperm fraction, and then the other sperm cell fraction. We then figured out how much DNA was in those samples. We then made many copies of specific regions along the DNA, and then we separated and detected those copies and established DNA profiles.
And so you spoke a little bit about fractions, and I want to talk just a little bit more in detail about that. Can you describe how this particular step in your analysis is able to separate, I think you said sperm cells from non-sperm cells?
Hang on a second, Mr. Bolden, if you'll just wait for just a moment.
Happened.
All right, you may ask that question again.
Ms. Sims, I believe my question was if you could speak in just a little bit more detail about how this differential extraction step is able to separate, I believe you said sperm cells from non-sperm cells.
It's called a differential extraction, and it utilizes the structure of sperm cells to its advantage. So we start by taking the cutting, putting it in a tube with chemicals to release the DNA. This will be any non-sperm cells. Then we are able to move that to a separate tube and categorize that as our first fraction or our non-sperm fraction.
All right, hang on just a moment, please. Yes, sir.
We may need to send the jury out for this one.
All right, ladies and gentlemen, I'm going to send you into the jury room. Please don't discuss the case.
That's interesting music by Brian. I didn't know you used to do that. That's cool. So you can tell us if she's on the money or not? Y'all, tomorrow is my son's 26th birthday, and we have another person in chat whose child's birthday is tomorrow, but I don't know if I can safe to share it.
You all may be seated. Before we get started, I just want to make sure that everyone in the courtroom has their cell phone put away and off. There's a lot of distraction going on from people coming and going in the courtroom to the outside and back again, and it is very distracting. And so, first of all, I'm going to ask everyone who's in the audience if you can remain seated as much as possible. That would be incredibly helpful. But also, our bailiff is doing a really good job of making sure that people are not using their cell phones, and I appreciate that very much. But she's in charge, and you cannot have your cell phone on or out. And so I ask everybody to cooperate. If you don't, you're not going to be able to stay. Thank you very much. All right, Mr. Cruz, go ahead.
Sure. So the testimony from Ms. Sims is extremely prejudicial because GBI, as a policy, they do not refer to second fraction cells as sperm because second fraction could be skin cells, it could be saliva, it could be sperm. But the testimony that Ms. Sims has given is outside of the scope of what she would be able to testify to as a GBI agent. She just looked directly at the jury and told the jury that she has non-sperm cells as well as sperm cells. And there is no evidence in this case, but it has been put before the jury at this time that the DNA that was found was sperm.
All right, thank you. Mr. Bolden, any response to the objection? All right.
Yeah, I disagree. I think that
Whether the witness is here. Ms. Sims, is there a GBI policy that you?
Mr. Cruz, we're
I'm
not going to
sorry,
go there.
I'm sorry.
Okay.
I'm sorry. But this is
So I'm making a ruling about your objection. We have had a hearing outside the presence of the jury where this court ruled that this testimony is admissible. We've gone through a lot of this, and I'm going to overrule your objection.
well. I'll ask you this, Your Honor. We didn't get into sperm at the. I think I'll say this. I don't think I'm asking for at this time is an instruction to the jury.
I
But
will.
if you're saying you're denying my request, I accept that ruling. But I would ask if I could have the opportunity to flesh that issue out for the purposes of the appellate record if need be.
Not at this time, Mr. Cruz, and I'm overruling your objection.
Yes, ma'am.
If you would like to submit some sort of jury instructions that we can talk about in terms of alerting the jury to your issues, we'll do that at charge conference. But this testimony has already been ruled admissible by this court at a previous hearing, and I'm not overturning that order. So
Yes,
that'll
ma'am.
be all. Thank you. Anything else before I bring the jury in? All right, you may bring the jury in. Thank you. You may be seated. Mr. Bolden, you may begin. If you
Thank
want
you, Your
to
Honor.
ask that question again, you may. We were, I've distracted you all from an announcement, so go ahead.
And Ms. Sims, basically what I want to get to is in the process of this differential extraction, does that always result in a perfect separation of male DNA from female DNA?
No, it doesn't.
Can you speak just generally to how, I guess, there might be some, it's a horrible word, but I can't think of anything else, commingling of those after a differential extraction?
It is sample dependent, and it can be how much male DNA or female DNA we had to begin with. There could be some carryover between both of the fractions.
Thank you. Now, after you perform this differential extraction,
Mine's
these
9
three
years
pieces of
older.
evidence, I think you talked about 2B, 2I, and 2J. Were you able to obtain a DNA profile from the first fraction of all three of those pieces of evidence?
Yes, I was.
And in all three instances, to whom did the DNA profile belong in that first fraction?
The DNA from the first fraction of 2B, 2I, and 2J all match the profile of Tara Baker.
Now, as it relates to the second fraction of each of these pieces of evidence, I think maybe we should go one at a time. So I want to speak first to item 2B, which is the rectal swab.
You may.
Yes, and it also is Abraham Lincoln's birthday. That is so true. And let's see. Yes, it's Courtney Dakota's birthday is tomorrow. I know they merged them all into, yeah, it used to be a special. It used to be a special independent day for Lincoln's birthday, but you're correct, they merged it. I don't know what to do for my son for his birthday. What are we doing?
I'm going to let you know. And I need to take care of a matter that is unrelated to this moment, but I need to take care of it now. And so I'm going to ask you to go into the jury room and not discuss the case. I'm going to let you step down and have a seat outside and stretch your legs and things of that nature. We'll be with you as soon as possible. Thank you very much. If you'll go into the jury room, don't discuss the case. And you may step down.
By the way, June, just want to let you know the company is resending the thing I sent you that you didn't get. So please keep an eye out. I don't know if it's shipped yet or not. I don't know.
Yeah, may I'll be seated. Thank you.
I know they'll always be our
A
babies.
couple of minutes.
Always will be our babies. Okay, let's see if they come back. They do. I expected that to be longer.
Make
So there's nothing.
You think, Joe? You think?
Y'all may be seated. Thank you. All right,
Not
ladies and
too
gentlemen,
sure.
thank you for your patience. We're ready to resume. Mr. Bolden, you may continue.
Thank you, Your Honor. Ms. Sims, I want to, okay, we were talking, if I remember correctly, about what data or conclusions you were able to make related to the second fractions on each of these three items of evidence, 2B, 2I, 2J. Does that sound right?
Yes.
Okay. I'm going to go a little out of order, and I want to start with item 2I. And two I, is that you have that marked as oral swabbings B?
Yes, that's what it was labeled as.
Okay. And so in the second fraction of item 2I, were you able to develop a partial major DNA profile in that particular fraction?
Yes, the DNA was obtained from at least two individuals, and a partial major DNA profile was developed that could not be contributed to Tara Baker or Chris Milton.
And was that partial major profile obtained that you said did not belong to Tara Baker, did not belong to Chris Melton? Was that eligible for entry into CODIS?
Yes, it was.
Okay. Is CODIS a national database of DNA?
It is.
And are there approximately 23 million samples in CODIS as of December 25?
Yes.
And once an item is entered into CODIS, is it compared on a routine basis to other profiles?
I'm going to
found
try
in
it.
that database?
Yes.
Okay, now I'm going to go back to 2B and 2J. Did you obtain information related to DNA profiles or potential DNA profiles in each of those items?
Yes, DNA data was obtained from the second fraction of both of those items. However, due to a complex mixture and low-level data, it was sent off to true allele analysis.
Okay. And would that be for each of those 2B, which is rectal swabs, and to J, which is, I believe, that's where I get really confused. Oral swabbing's A?
Yes.
And you mentioned that those were forwarded over to True Allele. Ms. Sims, are you trained in True Allele?
No, I am not.
Okay, and so that data, then just to be clear, was forwarded, ooh, almost dropped my pen, forwarded to another scientist who is trained to use True Allele?
Yes.
And just like before, Ms. Sims, as it relates to the DNA typing that you were able to do in this differential extraction process, did you create a report to summarize your findings
Yes.
just like before?
Yes.
Okay. I can approach Your Honor.
You may.
I'm going to hand you what's been marked as 6164. Is that just a copy of the report that you generated summarizing the findings that you just discussed with the jury?
Yes, it is.
Any objection?
No, ma'am.
It's admitted.
Ms. Sims, lastly, at some point after doing the DNA typing analysis that you just described, were you able to conduct DNA analysis with the partial major profile that you just described in item 2I, comparing that to a known sample of a DNA obtained from Edric Faust?
Yes, I was.
Okay. And from where did you obtain that DNA profile of Mr. Faust?
It was from a known reference sample that was submitted.
Were those buccal swabs?
Yes, those are buccal swabs.
Okay. And particularly as it relates to any analysis that you were able to perform between that partial major profile in item 2I and the known buccal or known profile obtained from the buccal swab of Mr. Faust, what were the results of that comparison?
The DNA that was obtained from item 2I, the partial major profile was compared and it was a match to Edric Faust, and the frequency in which we would expect the particular DNA profile, the partial major developed, is 1 in 800 quadrillion, and that's 800 followed by 15 zeros. And that's how often we would expect to see that particular partial major DNA profile in a given population.
So 1 in 800 quadrillion, did I get that right?
Yes.
And if you know, ma'am, approximately how many people are located on the planet?
Approximately 8 billion.
Ms. Sims, those are all the questions that I have for you. Defense counsel may have some questions. Thank you, ma'am.
Cross-examination, Mr. Cruz.
Good afternoon, Ms. Sims. How are you?
Good, how are you?
I'm doing well. Thank you so much for asking. My name is Ahmad Cruz, and I have the privilege and honor of representing Mr. Faust. Is it okay if I ask you a couple of questions?
Yes.
All right. I want to go back to something you mentioned on direct examination. You mentioned a non-sperm fraction and a sperm fraction. Do you remember making that statement?
Yes.
Did you test the DNA for sperm?
No, it's not a confirmatory test. The extraction method itself theoretically separates into those fractions.
Were you aware that GBI did conduct a sperm test?
On the
Swabs.
Swabs.
Correct, that you had.
I was not aware.
Okay, so you're not aware that the GBI determined that those swabs did not contain sperm?
I was not aware.
And just to make sure we're clear, you didn't test it for sperm. Is that right?
I did not.
And the swabbings that you tested, is it fair to say that you tested 2 oral swabs?
Yes.
Okay, and 1 anal swab.
Yes, labeled as rectum and oral A and B.
And pursuant to GBI policy and your testing, it is common to receive 2 or more oral swabs. Is that fair?
I think it depends on the specific kit, what you receive within the sexual assault kit.
Sure. What do you typically receive?
We typically receive orifice swabs. We do see oral swabs.
How many? Just typically on average.
On average, I usually see 1.
How long has the GBI had access to True Allele?
I'm not sure. I'm not trained in True Allele.
Okay. In this case, was it uncommon to receive 2 oral swabs?
I couldn't say.
Well, you said on average you receive 1. So you don't know if it's common or uncommon if you see 2?
I wouldn't say that I haven't seen 2 before, but I also, on average, I typically see 1 oral swab package labeled, but it is case specific and kit specific, what they collect and how they label them and what they submit.
Sure, that's fair. You've seen kits where you've had 3 oral swabs, is that correct?
Not that I recall.
Never?
Not that I recall.
And how long have you been with GBI?
Approximately 4 years.
How long have you been in the division dealing with DNA?
4 years.
Course indulgence. No further questions. Thank you.
Any redirect?
Joe, this is calm.
I forgot. My apologies. We were talking about the DNA analysis that you performed on that partial major profile from item 2I with the known reference sample of Edric Faust. Just like before, did you reduce your findings that you just testified to in the form of a report in that case as well?
Yes, I did.
Approach the witness, Your Honor.
Okay.
This is stage 165 in the sentence. Is that just a copy of your report related to the comparison that you did between that partial major profile and the known sample from the defendant at his house?
Yes, it is.
Any objection?
No objection. I think I have a continuing on the record regarding reports with hearsay, but otherwise, no objection.
All right, it is admitted.
Those are all the questions I have.
Any recross, Mr. Cruz?
No, ma'am.
May this witness be excused?
Ask that she be excused, Your Honor.
Any objection from the defense?
No, ma'am.
You are free to go. You may call your next witness.
Ashley Hinkle?
Sorry, did you say Hinkle?
Hinkle.
Could you get Ashley Hinkle, please?
Ma'am, if you could raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can have a seat. And ma'am, if you could start by just stating your name and spelling it for the record, please.
Ashley Hinkle, ASHLEY HINKLE.
And how are you employed, ma'am?
I'm employed at the Georgia Bureau of Investigation in the Forensic Biology Section in Decatur, Georgia.
How long?
Decatur.
What is your position at the GBI Crime Lab?
I am a forensic biologist. Technically, I'm called a Crime Lab Scientist 3.
CSI 3.
And how long have you been employed there?
It will be 20 years in July.
Can you please explain what your job entails?
Primarily, my job entails examining evidence for the presence of bodily fluids. If those are there, I attempt to attain a DNA profile from the evidence, and then I compare that to a DNA profile obtained from what's called a reference sample, which is a sample collected directly from an individual. I then write reports and peer review the work of other scientists. I'm also trained in a computer program for complex mixtures called True Allele.
And we'll certainly talk more about True Allele in just a few minutes. Can you speak a little bit to your education and training that qualifies you to perform those tasks that you just described?
I have a Bachelor's of Science in Biology from East Carolina University and a Master's of Science in Forensic Science from Marshall University. I also have extensive in-house training at the Georgia Bureau of Investigation and the National Forensic Science Technology Center in Largo, Florida. And I participate in continuing education on a yearly basis, as well as proficiency testing.
I would say so,
what
Joe.
is DNA?
DNA stands for deoxyribonucleic acid. It's found throughout our bodies in what's called our cells. It gives us unique characteristics, such as the color of our eyes and the color of our hair. And no two people have the same DNA except for identical siblings.
Can you speak a little bit to how DNA testing is performed?
The DNA testing, the traditional DNA typing service, is a small cutting of evidence is taken. It's added into liquid chemicals that help separate the DNA from the other biological material that's present. A robot is also used to assist in the separation procedure. When the clean DNA in a tube is the end product, and that is quantified to determine how much human DNA and male DNA is present. Those values are then used for the next step, which is amplification, where copies along the DNA strand of 21 locations plus 3 for gender that we use to compare between individuals. These copies of DNA, which are small fragments of DNA, are separated by size on a genetic analyzer, and the output from this instrument is used in a software program called Gene Mapper IDX, where the profile is typed. And the profile at the 21 locations should have no more than 2 pieces of genetic information, or 1 piece of genetic information in the form of peaks. 2, if the information is different, that is inherited from a mother and a father, and just 1 peak if you inherit the same piece of fragment of DNA from the mother and the father.
And so is that the process by which you obtain a DNA profile on a piece of evidence or from a known reference sample?
It's the same for a piece of evidence, which we call an unknown, as well as a reference sample called a known. The extraction for the unknown samples and the reference samples take place at different times.
Ms. Hinkle, I do want to turn now to True Allele. You mentioned that earlier. What is True Allele?
True Allele is what's called a probabilistic genotyping software. So it breaks down complex DNA mixtures into possible genotypes for individual contributors. The possible genotypes are giving a probability at each of these 21 locations along the DNA strand. This information, the genotypes and the probabilities, are compared to a reference sample of the individual. Then there is a result in the form of what's called a likelihood ratio. An individual can be included, not included, or there is a area between a match and a non-match, which we consider inconclusive.
I think you may have touched on this briefly in one of your earlier answers, but what would prompt one to use true allele, or when is it appropriate to use true allele to analyze DNA obtained from a piece of evidence?
We use true allele when the other methods we have to separate DNA into individual contributors. We're not able to do that. In order to separate a DNA mixture into individual contributors, there must be an imbalance between how much of DNA each person contributed, so that these little peaks that we look at are different in size. This difference in size can allow us to separate a complex mixture into individual contributors. We can also up to 3 individuals in a sample. If there is one major contributor, we can separate that major contributor. But if those methods don't work, then we can use the true allele software system.
Gotcha. Can you talk a little bit about any true allele training that you've had?
My true allele training started around 2017. We implemented true allele in 2018, but it consisted of reading background information on true allele, a small weekly presentations by the individual who developed the software and the company called Cybergenetics. We also practiced with mixtures where the contributors were known. These mixtures consisted of a mixture of DNA from individuals, most of them employed in the lab. So practice and literature review, because this was the first time we were using this software in the lab.
Has true allele been validated by the GBI crime lab to interpret low levels and or mixtures of DNA collected from items of evidence?
Yes, it has.
And has it also been subject to validation studies and peer review outside of the GBI crime lab?
Yes, it has. It's been used by other labs, so there have been other validations before they must use it, before they're allowed to use it in casework.
Do you receive ongoing training outside of anything that you already spoke about as it relates to true allele specifically?
The true allele people, not everyone in the lab is trained in true allele. So our group, we do meet and have, we discuss any kind of issues we have, or suggestions for improvement, and also new literature we read and discuss.
Have you used true allele software to interpret DNA samples?
Yes.
Any idea how many times?
Oh, hundreds.
Ms. Hinkle, have you testified in court before in the fields of forensic biology, forensic DNA analysis, and true allele or probabilistic genotyping in general?
Yes.
Approximately how many times?
Approximately 300.
Your Honor, at this time I would tender Ms. Hinkle as an expert in forensic biology, forensic DNA analysis, and true allele analysis.
Any objection by the defense?
No, ma'am.
All right. This witness is admitted as an expert in the areas of forensic biology, forensic DNA, and true allele analysis. You may continue.
Thank you, Your Honor. Ms. Hinkle, before we get into true allele, I know we just spent 10 minutes or so talking about true allele, but before we get into that, I want to ask you about something else. In this case involving a victim by the name of Tara Baker, were you recently asked to review a report that was generated by a former GBI forensic biologist by the name of Cynthia Wood, specifically DNA analysis that she conducted on certain pieces of physical evidence back in 2010?
Yes, I was.
Okay. And if I didn't make it clear, is Ms. Wood still employed by the GBI?
No, sir. She's no longer in the state.
What actions did you take to review Ms. Wood's analysis?
I reviewed her data. and I used it to write the report. So it was just a paper review of what's the information in our computer system that was available to reach my own conclusions and write a report.
And just so the jury understands, what items of evidence were analyzed by Ms. Wood back in 2010?
There was a ligature, which is item 6. There was a knife, item 15, as well as a bloodstained card labeled Tara Baker.
And did you have the opportunity to review the data that Ms. Wood relied upon to form her conclusions as to those pieces of evidence?
Yes, I did.
And based on your observations of her data and results, were you able to form your own conclusions as to DNA analysis that was performed on both the ligature and the knife?
Yes, I did.
Was a DNA profile obtained on both the ligature and the knife?
Yes.
Were you able to determine whose DNA was present on both?
Yes.
On each of those items, how many profiles were present?
Just one.
And to whom did that profile belong?
Tara Baker.
Did you make a report that kind of summarized your observations and review of Ms. Wood's data from back in 2010 that you used to come to your own conclusions?
Yes, I did.
If I can approach, Your Honor.
Okay.
This is stage 166. Is that the report that you generated after kind of going through the process of reviewing Ms. Wood's work?
Yes, it is.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
Ms. Hinkle, now we will go back to True Allele. Were you asked to perform True allele, excuse me. Bear with me.
I want to know if she was asked to
let's
perform
put
the
aside
Macarena.
The review of Ms. Wood's report now. In this case, were you also asked to perform certain DNA analysis using True allele that you described just a few minutes ago?
Yes, I did.
Could you please explain what data you received and how you used that data to run it through True allele?
First, I received the data from the second fraction from the rectal swabs, oral swabs B, and oral swabs A that were from the sexual assault kit of Tara Baker. I used reference samples to make a comparison, and those were of Tara Baker, Chris Melton, and Edric Faust.
And then actually, I think, was there a time that you used True allele to interpret this data, but without the known reference sample of Mr. Faust?
Yes, my first report was issued without having the reference sample of Mr. Faust.
And in that first report, I want to talk specifically about the partial major profile obtained in the second fraction of item 2I. Did you compare that profile against the known profiles of Tara Baker and Chris Melton?
Yes, I did.
And what, if anything, were your results?
For the second fraction from the sample from 2I, there was a major contributor. Chris Melton is excluded. He was approximately 300 duodecillion times less probable than a coincidental match to an unrelated person in the population. Tara Baker was also excluded, 1 tridecillion times less probable than a coincidental match to an unrelated person in the population.
And what was that report dated, Ms. Hinkle?
That report was dated May 2nd, 2024.
And so lastly, Ms. Hinkle, I want to turn your attention to a time when you used true allele to analyze pieces of evidence. However, this time with the additional, I guess, information that was in the form of a known DNA profile from Edric Faust.
Okay.
And were you able to run a subsequent true allele test, excuse me, involving items collected from Miss Baker's sexual assault kit, 2B, 2I, 2J, with the known reference samples of both Chris Melton and Edric Faust?
Yes, I used the information, the data that was already generated when I wrote the first report. All I had to do was compare it to the reference samples.
And we'll go through each item of evidence and talk a little bit about the, is it likelihood ratio? Am I getting that terminology correct? The likelihood ratio that was reported for each. Let's start with item 2B, which is the rectal swabs. Can you tell the jury what information that you were able to learn about the second fraction of item 2B?
The second fraction from the rectal swabs, 2B, there was a match between the data from the second fraction from the rectal swabs and Chris Melton. This match is approximately 60,000 times more probable than a coincidental match to an unrelated individual. And the comparisons between Tara Baker and Edric Faust, between their reference profiles, is inconclusive because meaningful match statistics were not obtained. That's just our way of communicating that their results fell within an inconclusive range, where during our validation, we had false matches and false exclusions. So in between this range, we do not report a match or an exclusion.
Gotcha. Ms. Hinkle, based on your training and experience and coupled with the results of true allele on item 2B, the rectal swabs that you've just described, is opinion that might be significant in finding someone's DNA being present in this particular piece of evidence, aside from that individual engaging in anal intercourse?
Besides from anal intercourse, it is not unusual for there to be drainage from the vaginal area into the rectal area. Also, wiping from one area to another can transfer the DNA so that even though there's not anal intercourse, an individual's profile can show up in the second fraction of a rectal swab.
Is there anything else based on casework that you've done that might be significant in, again, finding someone's DNA in this particular orifice?
There's another way for DNA to be transferred from the vaginal area to the rectal area. That would be transferred by another individual. For example, I worked a case and that has already gone to court, but it involved an individual who was tied down and sexually assaulted a female. And then her girlfriend knocked on the door to find out where she was, and she was dragged in and sexually assaulted. So even though these two females never had contact with each other, the female who was tied down in the bed, the other victim's DNA was found on her.
Ms. Hinkle, I want to move now to true allele analysis as it relates to item 2I. Can you describe for the jury the results of your DNA analysis using true allele on that particular piece of evidence?
For the second fraction from the oral swabbings 2I, there was a major contributor. The match with this major contributor data from the second fraction from the oral swabs and Edric Faust. This match is approximately 30 octillion times more probable than a coincidental match to an unrelated person in the population. And due to limited data, no conclusive determinations could be made about the minor evidence genotype from the second fraction from the oral swabs. And there were at least 2 individuals in that DNA mixture.
To include, as you just testified, the likelihood ratio, one of those being Mr. Faust, am I understanding that?
Correct. The major contributor was a match 30 octillion times more probable to Mr. Faust.
30 octillion. Can you speak a little bit to the size of that number?
Octillion is
Huge.
27 zeros,
Huge.
so 30 would be an extra zero, so 28 zeros. It's a large number.
Lastly, Ms. Hinkle, I want to move on to item 2J. Can you speak to the results, if any, that you obtained using True Allele on item 2J?
For item 2J, there was a match between the second fraction from what was described as oral swabs to Chris Melton. This match is approximately 8 octillion times more probable than a coincidental match in an unrelated person in the population. There was also a match between the second fraction from the oral swabs and Edric Faust. This match is approximately 70 billion times more probable than a coincidental match to an unrelated person in the population. And there was a third person in this mixture. It was a mixture of 3 individuals. And again, I could not make the results for the comparison to this minor contributor, and Tara Baker fell within this inconclusive range.
May I approach one last time?
May.
Ms. Hinkle, I'm going to show you what I've marked. It's 167 and 168. It states exhibit 167, a copy of the report that you generated on May 2nd that involved True Allele analysis without the known reference sample of the defendant Edric Faust.
Yes, it is.
It states 168, a copy of the report that you just most recently been testifying about, which is your True Allele results with the added known reference sample from Mr. Faust.
Yes.
Any objection? They are admitted.
Just a few more questions, Ms. Hinkle. So, ma'am, based on your training and experience, can you speak a little bit to the amount of time that a forensic biologist might reasonably expect to find DNA present in, say, an oral swab versus a vaginal swab?
For an oral swab, based on the literature I've looked at, 24 hours is around the maximum time. 5 to 6 hours is more credible as far as there still being enough male DNA present in the oral cavity for us to test. As far as vaginal swabs, 7 days has been the reported max. We like to see the kits collected within 72 hours, though, for best results.
But 77 days or a week would be like the kind of the far end.
That's at the far end, yes.
Okay. And can you speak a little bit as to why the detection period for these 2 places in the body may be different?
The oral cavity individual is going to will spit out the sample possibly, or brush their teeth or drink before the sample is collected. And that decreases the detection of the male DNA in the oral cavity of a living individual. For the vaginal area, it survives longer in the vaginal canal, but that does vary. Because it's of the conditions in the vaginal canal, and because of the sperm themselves have a protective layer that help them to survive in the vaginal canal. They are there for a longer time.
Ms. Hinkle, based on your training and experience, coupled specifically with the true allele results that you obtained on, I think, June 11th of 2024, specifically as it relates to items 2I and 2J, do you have an opinion, ma'am, as to whether or not those items were collected from the same part of the body of the victim?
Yes, I do have an opinion.
What is that?
Well, the profiles that were obtained from these two items were distinctly different. One was a major contributor and a minor contributor. So the 2I was at least two individuals, a major contributor and a minor contributor. The 2J, though, was at least three individuals, and two of those individuals were able to match. But there was also the presence of a minor contributor. So if the same cavity is swabbed, we would expect similar results in the DNA typing.
Based on I think you said nearly 20 years that you've spent at the GBI Crime Lab. Am I remembering that right?
Yes.
Would it be unusual to you in your training and experience to not receive vaginal swabs if there was suspected vaginal penetration?
It would be
assault.
It would be unusual, yeah, and especially coming from a sexual assault kit of a deceased individual, when they don't know what type of sexual interaction occurred, they will sample the three orifices.
And those would be, just to be clear,
oral, rectal, and vaginal.
Ms. Hinkle, those are all the questions I have for you, ma'am. Defense counsel may have some questions. Thank you.
Cross-examination, Mr. Cruz.
Good afternoon, Ms. Hinkle. How are you?
Thank you.
My name is Attorney Ahmad Cruz. As you know, we've had opportunity to speak, and I represent Mr. Edric Faust. Is it okay, Ms. Hinkle, if I ask you a couple of questions?
Of course.
Okay. We'd agree that you've been with GBI for 20 years. Is that correct?
Almost, yes.
Okay. And you have a supervisory position. Is that correct?
No, I do not.
You mentioned that you oversee, I thought I heard on direct that you said you oversaw or you reviewed others' work. Am I mistaken on that?
That's a process called peer review, and all the scientists in the section, we report DNA services, but we also review the services that other individuals complete, just to have a second set of eyes on the results before they are released.
Okay. But that's pretty much your coworker would do the same thing. It's not a supervisory process.
Correct.
Okay, perfect. In this case, you reviewed 2 oral swabs and anal swab. Is that right?
That's what they're labeled, yes.
Okay. And is it uncommon to receive 2 oral swabs per GBI policy?
Sorry.
Is it uncommon to receive 2 oral swabs per GBI policy?
2 separate sets. It's not really a GBI policy because it's collected by other individuals, but it would be unusual to receive 2 sets of oral swabs and no vaginal swabs.
Is it possible that the vaginal swabs may have been, well, you wouldn't know. What year did you test these items?
It was recently, so the Trulil was in 2024.
Okay. So you don't know if the absence of a vaginal swab is due to a loss?
I can't say. I wasn't there.
That's fair. That's fair. But you have seen cases where you've seen 2, 4 oral swabs, things of that nature?
Usually if there's multiple swabs, they're within the same envelope and not in separate envelopes.
These were in separate packages that you received them, A and B?
Those, yes, separate envelopes.
I'd like to talk to you about the DNA obtained from the second fraction from the rectal swab. Is that fair?
Yes.
I believe your testimony on direct examination, you stated that there were, at least 3 individuals
Correct.
in the DNA mixture?
Correct.
And Mr. Melton's DNA profile was the only identifiable DNA profile. Is that correct?
Correct.
And 1 in 65,000, that's still a strong likelihood ratio. Is that correct?
It's 1 in 60,000. And based on our validation, any match over 1 in 10,000 times more probable is what we report, because we observed no false matches over 10,000 times more likely. So yes, it is a match. It's on the lower end, but it's still, based on our validation, should not be a false match.
Okay, that's fair. And you stated that in regards to the inconclusive range, you can't give an opinion whether a person is present or not present there.
Correct.
And is it fair to call Mr. Melton's DNA that was identified in the anus as male second fraction DNA? Is that fair?
It was in the second fraction, yes.
Excellent. And you didn't test this fraction for sperm, is that correct?
Correct.
And is it fair to say that second fraction DNA could be sperm, skin cells, blood, or saliva?
The aim is to obtain only a profile from the sperm, but there can be some crossover of other types of DNA, other types of cells into that second fraction. So it's difficult to say.
Yes, ma'am. Was it difficult to say that the second fraction could be skin cells, blood, and saliva? Are you saying that's difficult to say?
We're told not to say that it.
Well, I don't want you to say anything you're told not to say.
Yeah. We don't say it's something unless we know it's something.
Certain.
So I don't want to go out.
Okay, understood. That's fair. That's fair. Are you familiar with the Journal of Forensic Sciences article entitled "The Persistence of Sperm and the Development of Time Since Intercourse Guidelines in Sexual Assault Cases"?
That's one, yes.
Are you familiar with that one?
Well, I've recently reviewed.
Yes, ma'am. I would like to show you that document if it's okay. Okay, I'm going to ask you some questions off of that document.
Okay.
Let the record reflect that I'm showing the state what has been marked as Defense Exhibit 52. Let the record reflect that I am showing the witness what has been marked as Defense Exhibit number 52. There you go. And Ms. Hinkle, please take your time, review that document. Once you're comfortable that it is accurate, it hasn't been altered in any way, please look up for me. Okay. Is that document a reliable authority in your field?
The journal is.
Yes, ma'am.
And they would not accept a paper without a review before it's published, so it would be reliable.
Yes, ma'am. I would like you to look at page 588 of that document. I'd like you to look at the last paragraph. On the left column.
It's 588.
Yes, ma'am, 588.
Okay.
All right, and then we're looking at the left column and the last sentence on the left column. You'd agree that it states, in general, sperm can be detected in the anus up to 24 hours time since intercourse. Is that correct?
That's what it states, yes.
Okay. And it says sperm can persist for over 2 days after intercourse. Is that correct?
2 days after anal intercourse.
Yes, ma'am. And then at the top, we have table 8. Do you see table 8 at the top on the right column? And there were 5 anal swabs. And I'm sorry, we're looking at the 96 hours to 120 hour range. Do you see where there was 5 anal swabs tested in that 5-day range?
There were 5, yes, that were tested after that range.
Okay, and all 5 came back as negative for the presence of DNA. Is that correct?
Yes.
In the middle of that paragraph, and we're on the right side now, it says the expectation. I'm sorry, we're at the. I'd like you to go to the 4th sentence, the first paragraph on the right side of the document. And it starts with the expectation of finding. Do you see that, Ms. Hinkle?
Yes.
It says the expectation of finding anal swabs positive for, and I'll just say DNA instead of that word, at a time since intercourse of less than 48 hours can be considered low. And the expectation of finding DNA at time since intercourse greater than 48 hours can be considered extremely low. Is that correct?
Well, it was expectation of finding sperm greater than 48 hours can be, yes, that's what it says.
Okay. And 2 sentences down, it says, our experience at FSI, which is the journal, is that it is unlikely that sperm would be detected on internal swabs beyond a TSI, which is time since intercourse, of 24 hours. Is that correct?
Their experience at the institution that did this study, correct.
Are you also familiar with course indulgence? The Canadian Society of Forensic Science Journal article providing evidence-based opinions on time since intercourse based on body fluid test results of internal samples. Are you familiar with that?
Yes.
Court's indulgence. And I am marking this document as defense exhibit. Can you say the number of the exhibit that you have?
52.
52. So this would be marked as defense exhibit 53. Thank you. Oh, that is the wrong copy. I am so sorry. That is my copy. Yeah, that's the wrong copy. This is your copy. There you go. Is it okay if I approach you, Dr. Ms. Hinkle? I want to call you doctor. Please forgive me. And please take your time and look over that document once you've had opportunity to look over it and make sure it hasn't been altered in any way. And you recognize it, you can look up. That article that I just handed you, is that established as a reliable authority in your field of work?
The journal, yes, and they wouldn't accept an article, an item for publication unless it is valid.
Yes, ma'am. 1 second, Ms. Hinkle. Thank you for your patience. And you're familiar with the Canadian Science of Forensic Sciences, the Canadian Society of Forensic Science Journal article providing evidence-based opinions on time-since intercourse based on body fluid testing results of internal samples. Is that correct?
Yes.
I would like you to look at page 61. I would like you to look at the last paragraph on page 61. And would you agree that the first sentence of the last paragraph of page 61 states, in the literature review, the maximum reported time frames from the detection of spermatozoa were 7 days for the vaginal cavity. Is that correct? 3 days for the rectal cavity. Is that correct?
Correct.
And less than 24 hours for the oral cavity. Is that correct? Court's indulgence.
That be mama calling and checking on me, y'all.
Were you asked to conduct any DNA testing on hairs found on Ms. Baker's body?
I was not.
Is that a capability that GBI has?
It is one, yes.
Thank you. I have no other questions.
Any redirect, Mr. Bolden? All right.
Ms. Hinkle, you were asked several questions on cross-examination about the detection period. Come over here to the microphone. Of the detection period for male DNA in a rectal swab after anal intercourse. Going back to the case that you specifically referenced on direct examination, where an individual was able to transfer DNA from one victim to the next. In that context, would that reset, or not even reset, would that start the detection period for potentially DNA being located on an anal swab? Does that question make sense?
Yes. I mean, it's possible for an individual to transfer fluids from the vaginal into the rectal area if there is insertion in both areas. So it would kind of restart the clock.
What about drainage? I can't believe I just said that. What about drainage? I'm sorry.
So to speak, as far as the time frame.
That's all I have, ma'am. Thank you.
Any, excuse me, any requests, Mr. Cruz?
No, ma'am.
May this witness be excused?
I would ask that she be excused, Your Honor.
Any objection, Mr. Cruz?
No, ma'am.
You are free to go. You may call your next witness.
Okay, so let me get it here. Let me get this. Court feed back up. Come on. My mouse is still squirrely as hell. Of course. Here we go.
Absolute right to testify, but you also have the absolute right to remain silent. If you choose to remain silent, I will instruct the jury that they are not allowed in any way to use that against you or to hold that against you or to consider it in any way. All right, thank you. Mr. Cruz, anything you'd like to articulate to the court?
Thank you, June. I'll show it in a minute.
A couple of things. Before we get into the case, Sharon, I want to let you know that I just found out my wife is in the hospital. So we'll need to address that shortly.
Right.
But to take care of Mr. Faust's matter, I've advised Mr. Faust he doesn't need to testify in this case.
Okay.
So I'll stop there for now.
All right.
I also have a motion as well.
All right, go ahead with your motion.
We're gonna
Wait. I love that voice. You told him he doesn't need to testify. But that's not what needs to happen here. You can't tell him he needs to testify or not testify. You can talk to him and give him your advice, but he has the right to testify even if you don't think he should testify. So what we want to hear from you is, no, I told my client he doesn't need to testify. We're good. Let's move on. That right there, if that can be an appellate issue, if the judge does not ask the proper questions and voir dire him, making sure that he understands his right, whether he should testify or not, anyone making him or forcing him to not testify or not. If all that doesn't happen, that's a huge appellate issue. Huge. Let's see what they do, because this is that. Nope.
For a directed verdict in this case, the law provides that on a motion for directed verdict, the evidence must be construed in the light most favorable to the party against whom the motion is sought. So, as the Honorable Court is aware, the evidence has to be viewed in the light most favorable to the prosecution in this case. A directed verdict is authorized only when there is no conflict in evidence. So, if, as the Honorable Court is aware, If I present evidence of one thing and the state presents evidence of one thing to that count, there cannot be a directed verdict. It has to go to the jury. And that's as to any material issue and the evidence introduced with all reasonable deductions therefrom, demand a particular verdict. So the counts that we were asked for a directed verdict to, first we'll start with burglary, Your Honor. In this case, and I believe that is burglary is count 6, Your Honor. And in the indictment, Mr. Faust is charged for the said accused in the county of Clark and state of Georgia on or about the 19th day of January 2001, did unlawfully and without authority enter into and remain in the dwelling house of Tara Baker with the intent to commit a felony therein, to wit, aggravated sodomy and rape in violation of OCGA 16-7-1. The evidence in this case presented in regards to the burglary count, as the Honorable Court is aware, none of the state's witnesses have disputed that outside of Mr. Faust's DNA being in Ms. Baker's body, there was no evidence connecting Mr. Faust with the home. In fact, the state mentioned in opening that they can't present evidence of how Mr. Faust got into the home. So in regards to count 6, our position is the evidence does not conflict. The evidence is actually favorable to the defense, even if viewed in the light most favorable to the state, because there is no evidence presented that puts Mr. Faust in the home or shows that Mr. Faust was in the home at any time. In regards to aggravated sodomy, Your Honor, all the testimony in this, and let me make this specific, the aggravated sodomy count involving the anus of Ms. Baker, which is count 10. So far we've done count 6. Next is count 10. All the evidence in this case, in regards to aggravated sodomy, it is undisputed that Chris Melton's DNA profile is the only identifiable DNA profile in Ms. Baker's anus. Dr. Falzone testified that based on her injuries, they were consistent with sexual assault. Ms. Hinkle testified that the anal DNA only lasts for according to the articles, 2 days to 3 days at most. The state asked her a question, their very last question to Ms. Hinkle. They said, could the timer reset? As the Honorable Court is aware, viewed in a light most favorable to the state, we have to accept that Mr. Melton last saw Ms. Baker on Sunday, last had sexual intercourse on Sunday. If we give Mr. Melton the 3-day window, that puts us at Wednesday with his DNA in Ms. Baker's anus. However, the DNA wouldn't still be present because the state's allegation is that Mr. Faust committed these acts on Friday. So there is no evidence that the state has presented or that could be construed even when construed in the best light, even when construed favorable to the state, there's no evidence that would support or that conflicts in regards to Mr. Faust being in Ms. Baker's anus. So we ask for a directed verdict on that count. In regards to count 11, arson in the first degree, we're also requesting a directed verdict. Again, it flows, the state has presented no evidence whatsoever that Mr. Faust was in the home. The closest the state came to that is, if we view the evidence in the light most favorable to the state, is that African Americans were seen walking around the Deer Park neighborhood on the day of Ms. Baker's death. But the state has presented no evidence. There's no conflict in the evidence. There's absolutely no evidence supporting that Mr. Faust started a fire in Ms. Baker's home. And again, what we rely on is the evidence presented through the reports as well as the testimony that law enforcement officers did not find anything connecting Mr. Faust with the home. The only place Mr. Faust's DNA was located, again, Your Honor, was Ms. Baker's body. That same reason it flows to count 12, possession of a knife during the commission of a felony. There's been no evidence presented that Mr. Faust had a knife or possessed a knife in this case. as well as count 9, count 8. Excuse me. So count 9, not count 8 or count 7. Count 6, we've discussed. And counts 1 through 5, which are malice murder, felony murder, felony murder, felony murder, felony murder. And just for purposes of the record, I address count 7 and 8. The evidence viewed in the light most favorable to the state, Mr. Faust is, and obviously we disagree with it, but we have to view it in the light most favorable to the state. DNA is in Miss Baker's mouth and in Miss Baker's vagina. Again, we disagree with that, but I understand the standard. We have to view it in the light most favorable to them. And the state's position is the reason it's there is because of rape and sodomy. There is a conflict in evidence there, so we're not requesting a directed verdict on those 2 counts.
Which 2 counts?
That is 7 and 8. 7 is the aggravated sodomy involving the mouth. 8 is the rape. And of course, Your Honor, our position is there was no rape that took place in this case, but I have to,
not asking for a directed verdict.
based on the law and viewing the evidence in the light most favorable to the state. But in regards to the murder counts, again, there's been no evidence presented by the state that Mr. Faust was responsible for Miss Baker's murder, outside of just his DNA being present. And as Honorable Court is aware, when it comes to murder, malice murder, they specifically state on or about the 19th day of January 2001, Mr. Faust did unlawfully and with malice aforethought caused the death of Tara Baker, a human being, by strangling her with a cord and stabbing her. The only evidence in this case regarding forensic material related to the murder weapon, which is the cord, is that Mr. Melton's trace evidence was found on the charger block that was next to Miss Baker's head that was connected to the cord used to strangle her. In regards to felony murder, burglary well, it should be burglary in a dwelling. Here it says burglary to a dwelling. Again, there's no evidence that a burglary occurred. The state admitted in their opening that they can't present evidence of how he got into the home. In regards to count 3, felony murder, aggravated sodomy. Again, the basis of that felony murder is the strangulation, and I've already provided the Honorable Court the facts and evidence that came out in this case in regards to the strangulation in count 3. And count 4, felony murder as related to rape. The felony murder piece of it, again, there's no evidence of murder. And I emphasize in other courts where we disagree that a rape occurred, we disagree that the aggravated sodomy occurred, but understanding the law, we understand we have to accept that evidence and say is favorable to the state's position. But in regards to the murder piece, there is no conflicting evidence on the murder piece. In fact, there has been no evidence presented by the state that Mr. Faust committed this murder again, but solely that his DNA was present. So we would ask the Honorable Court to grant our motion for directed verdict on all counts, excluding count 7 and 8. We believe those matters are appropriate for the jury based on the conflicting evidence.
Thank you, sir. State care to respond.
Yes, Your Honor. I mean, I'll be brief. The court has sat on the trial of the case. You've heard all of the evidence, but certainly not only has the state carried its burden to provide evidence sufficient to get this matter to a jury, but the state's carried its burden of proving guilt beyond a reasonable doubt that Mr. Faust committed all of the crimes that are named in this indictment. I'm going to start at the top and work my way down, but in some ways, the evidence of Mr. Faust's guilt applies to each of these offenses. So I think that the evidence as shown at trial shows that an individual matching Mr. Faust's description was seen in the area of 160 Fawn Drive and in fact disappeared.
Wait a second. Not as bad as earlier today. Go ahead.
That was much faster than earlier today, but there was an individual matching Mr. Faust's description that arrived in or was walking in the immediate area of 160 Fawn Drive and then was seen to disappear in such a manner that that individual's only route of travel would have been between the homes immediately around 160 Fawn Drive. Further, there is obviously evidence that a murder was committed. There is also obviously evidence that a rape was committed, as well as aggravated sodomy, both orally and anally, is evidenced by Dr. Falzon's testimony about the forceful nature of both the vaginal sex and the anal sex, as well as evidence giving proving Mr. Faust's guilt beyond a reasonable doubt, much beyond the necessary standard for a directed verdict, especially when viewed in the light most favorable to the state. There are only 2 DNA profiles found within the home in Miss Baker's body. One of them is from her boyfriend, who had been in a loving relationship with Miss Baker, and whose DNA was found within a normal detection window, as testified to by the GBI witness in Miss Baker's vagina, and then explained as far as the presence in the anal swabbing at a much reduced match or frequency rate due to either drainage or transfer from the period of time in which Mr. Faust raped Miss Baker, orally sodomized her, anally sodomized her, and then murdered her by stabbing her and strangling her with a ligature, Your Honor. And so when we're talking about directed verdict, the manner in which the court views the evidence, as well as considering the significant evidence in this particular case, the state's met its burden as it relates to counts 1, 2, 3, 4, 5, 6. The defense is not moving for a directed verdict on counts 7 and 8. If they were, the state would have met its burden there. As to count 9, the state has met its burden. Count 10 and 11 as well, and count 12. Obviously the knife was possessed during a commission of a felony as evidenced by the fact that Miss Baker's blood is on the knife itself, and it was a major contributor or the cause of death, along with the ligature strangulation of Miss Baker. And Detective Leadall testified as to the length of the knife being sufficient, being greater than 3 inches in order to satisfy the requirements of the statute, and as well as the arson being committed by the individual who had raped and sodomized and murdered Miss Baker, which would be Mr. Faust, as shown by the evidence in this case. I'm not going to go through a further recitation of the evidence because I know the court has sat in the trial of the case, but certainly the state has presented more than sufficient evidence both to survive a directed verdict and convict Mr. Faust as to all of those counts.
All right, thank you. Anything further? This is your motion. All right, thank you, sir. All right, so I know all counsel is aware of what this moment means and what the court's responsibility is, but I'm going to articulate it anyway. This is a moment where the court has to consider this statute, OCGA 17-9-1, when direction of verdict of acquittal authorized. When there is no conflict in the evidence and the evidence introduced with all reasonable deductions and inferences therefrom shall demand a verdict of acquittal or not guilty as to the entire offense or to some particular count or offense. The court may direct the verdict of acquittal to which the defendant is entitled under the evidence and may allow the trial to proceed only as to the counts or offenses remaining, if any. That's the law. That's what, Mr. Cruz, you have asked the court to grant under 17-9-1. And at this stage of the game, the court is not making any comment on the evidence. I want to make that clear. But what I am going to comment on is whether there is a conflict. That is what I have to find out. And if the court finds there is a conflict, the court has to deny defense's motion. I mean, that's just where we are. And so I want to just lay that out there. This court is not making a comment on the evidence, on the strength of the evidence, on the credibility of the evidence, on the lack of credibility of the evidence, the believability or not believability of the evidence. This is just a moment for the court to talk about whether there is a conflict. Both parties have articulated many times throughout the last 2.5 weeks the indisputable comment that this is a cold case. And in so articulating from both parties that this is a cold case, the parties have described in their ways why the evidence is or is not what it is. And a cold case, particularly one like this, is based on circumstantial evidence. And therein defines, in many respects, what a cold case is. And when the court charges the jury with the law that they must apply, one of the charges relates to circumstantial evidence. And juries are authorized to consider circumstantial evidence in making their decision. They don't have to, but they are authorized to do so. And they can give it whatever weight they care to. The court also charges the jury about circumstantial evidence, and in doing so also says that circumstantial evidence and direct evidence have the same weight, if any, and that one is not greater than the other. And any weight that is given to evidence is solely on the jury's shoulders. They get to decide whether they believe or they do not believe circumstantial evidence, whether they believe or they do not believe direct evidence. And that's the law that the courts give to every jury. That's your basic, I mean, obviously I'm paraphrasing. I'm not going to go back and read the whole charge to everyone. And I know counsel understands this, but I want to remind counsel that that's what the law is. And so based on all of that, and based on the law 1791 that says when there is no conflict in the evidence, I'm going to deny your motion, Mr. Cruz, for those reasons. This is a circumstantial case, and the argument that you have made relates to evidence that is direct evidence. This is a case that is not really direct evidence, although you all can argue however you choose to about what the evidence actually is. But this is a case about circumstantial evidence, and the evidence that has been presented, therein lies the conflict. Both parties have had the opportunity to direct and cross-examine, and the evidence that has been presented to the state is the epitome of conflict. And so for those reasons, I'm going to deny your motion, Mr. Cruz, because it is the law. All right. We've gone through that. Let me have counsel at the bench. Let's talk about some scheduling matters. And so, thank you.
Okay, so she did not, unless I missed it, and we're going to.
Earlier.
I don't think.
I hope you've had sufficient time to speak with your counsel. I want to
Listen.
make sure you understand that you have the absolute right to testify, but you also have the absolute right to remain silent. If you choose to remain silent, I will instruct the jury that they are not allowed in any way.
Okay, she
to
did
use
do
that
it. We
against
missed
you,
it.
or to hold that against you, or to consider it in any way. All right, thank you. Mr. Cruz, anything you'd like to articulate to the court?
A couple of things. Before we get into the case, Sharon, I want to let you know that I just found out my wife is in the hospital. So we'll need to address that shortly.
Right.
But to take care of Mr. Faust's matter, I've advised Mr. Faust he doesn't need to testify in this case.
Okay.
But he didn't
so
say
I'll
anything.
stop there for now.
Right.
Wait. But he did not stand up and say, "No, Your Honor, I do not wish to testify." He was just sitting there quietly, and his lawyer comes in. I'm sorry, the lawyer's wife is in the hospital. I hope she's okay. Out. I'm surprised this other council doesn't. So they're probably they're probably not going to finish the day because the wife is in the hospital, in my humble opinion. Um, in my humble opinion. Which is okay because I've got to go to Bernie. I hope that helped y'all. So tomorrow we'll start, Lord willing, if he's able to be in court, we'll start tomorrow with the defense's case in chief. So we've had 8 days of
You all may be
prosecution.
seated. Ladies and gentlemen, I'm going to release you for today. It's 4:20, and we're not going to start tomorrow until noon. It is possible that we actually may have all of tomorrow off. It's just going to depend on some circumstances. So if that is actually the case, you're going to get a call from the clerk's office, and they will tell you as soon as they know whether tomorrow is a free day for you. In the meantime, I want you to expect to be here at noon tomorrow. When I release you, of course, the same prohibitions apply we've been talking about for 2.5 weeks. I know you've been paying attention to that. Don't discuss the case with anyone. Don't do any research. Do not go to any of the locations that you may have heard about. Certainly try to avoid all social media that may have anything to do with this case whatsoever. Other than that, thank you for your patience today. I'm going to release all of you, and we will hopefully see you at noon tomorrow, but make sure that you pay attention to your telephone just in case. Thank you. You are all free to go.
Okay, so that will leave us to start a new case tomorrow. I'll decide that later tonight. But make sure that you will. Oh, I got to do the like, comment, and all that kind of stuff. You guys go to the while I'm talking to you, please make sure you've liked, subscribed if you haven't, shared if you haven't. Make that, you know what to do, because I'm going to be drawing for names in just a minute. But tomorrow we may be starting. If they're not going to be starting tomorrow, we'll be watching a new case. And then if they go live, we'll switch over. I'll do a whole new live. I'm not going to stay in the same live. So I'll create a new live and we'll go over into that one. And then if we're off all day tomorrow, well, then we'll stay in the other trial all day tomorrow. Thank you. Hi. Rocio Flores, 6768. Thank you so much for joining. If I didn't see you earlier, my problem. My bad. I don't know if I saw you commenting or not. No, I didn't. Thank you guys so much for joining. Okay, let's get to going. Let's see. We have no subs. One shared. You automatically have your entry in. No joins. Okay, so let's do the I liked, and here we go. And I should have put the music on. All right, Miss Sarah, congratulations. You won. Wonderful. Okay. Uh-oh, I thought I heard something. Let me go back. Could have sworn I heard something. Let me go back and see if they're still live. No, they're not. Okay. So we will see you guys tomorrow morning. I will have a thumbnail up. I'm going to be doing a short. It will be after 8:30, 9 o'clock tonight. I've got a meeting, but before I go, I do want to put this up. We have a silver alert. Missing 70-year-old man with schizophrenia traveling on foot in El Paso, Texas. So if you see this guy, if anybody, I put these up. Here it is again. We hope he's found safe. Thank you so much, my mods, for finding that. Both of my mods, thank you so much for being here. I appreciate and love you. I know it's been a crazy week for all of us, technically and otherwise, but we will see you guys tomorrow. And please please watch the little shorts. You get some information in there. I have comments and I have polls and things on the Facebook page. Make sure you go and do the clicky thing. All right. Thank you again, everybody. See you tomorrow morning. Have a great day. Bye. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next